May I please your lordship, my lord? Sir, in item number 47, lordship, as per your lordship direction, we have filed one affidavit yesterday, lordship. That record may kindly be called for, lordship. Deeply obliged.
May I please, my lord, item 53, supplementary list. May I pray, my lord, for upgradation, my lord. The petrol pump, my lord, has been allotted in her name. Now it has been cancelled by applying a wrong criteria, my lord. So, apna lage.
We'll see when the matter
Well,
is.
well, obliged.
May I please, Your Lordship? Item number 31, I have filed an affidavit in reply yesterday. Let me come back.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 32. Lordship, we are for the respondents 1 to 3. Mr. Raj Gupta, the learned counsel, is out of town. So it may be fixed for 10th of August.
One. Why? 10th of August.
Any date, lordship.
The request of the learned. Same order?
No, lordship.
Yes, it is. Your Lordship, there is an
5th of September.
My lord, I'm for respondent number 427.
No interim order?
interim order is there, Your Lordship.
Interim order is there?
Stay is there.
And
Yes,
we
lordship.
will get it. Not going to extend the interim order on the ground of a senior counsel, Mr. Oh, sorry. Senior counsel, there's no question of any adjournment. And you ask for, yeah, do the matter by yourself.
Lordship, we are ready to do the, for the petition.
It pleases your lordship. I draw your lordship indulgence to item 42, my lord. That is very well. My lord, there are some talks which have taken place. Showed that some talks between the GMP park matter, my lord. So they have assured that compensation.
No, there is some settlement that we need to have. We'll inform, my lord. They don't want passing with them.
Submitted by the counsels at the bar.
My lord, may I?
Out of courts. No, that certain talks are going on as regards the settlement of dispute. Accordingly, the matter stands adjourned
My lord,
and to be listed on mentioning it before the registry.
my lord, may I submit further, my lord? This, my lord, pendency is coming a bar, my lord, in settlement. So, my lord, may be permitted to withdraw and, my lord, with a liberty, my lord.
No liberty business. I don't give liberty like this. Liberty is a very difficult thing here.
My lord,
What do you,
I have instruction to withdraw, my lord.
42? Then you say that,
My lord, I was just trying.
don't come up with all these things. Mr. R.K. Batra, the learned counsel, submits that he has instructions to withdraw the instant application. View of certain talk, in view of assurance being given that the matter would be, that the dispute would be resolved by way of a compromise. Ms. So-and-so, who appears on behalf of MDA, and Ms. P. Borua, who appears on behalf of respondent number 2, 3, and 4, also submits that their talks of compromise are going
Yes,
I
sir.
feel person of 5 and 6, Smart City and G.
for the respondent number 5 and 6. Taking into account the above, the writ petition stands closed.
72.
Obliged.
Oblige, your lordship.
It please, Your Lordship, in item number 32, I have filed an affidavit. I am allowed to bring that. Deeply okay.
It is Lordship. Lordship, with regard to item number 26 of today's list, we are filing an affidavit in opposition. I may be allowed to bring it on record. Yes, Obliged.
May it please your lordships, my lord, in item number 20, my lord, we'll be filing one amendment application, lord. Therefore, lordships be adjourned for the day, man.
Interim order,
There is no interim order, my lord. We have consent of the other side, lordships.
well, item number
20, my lord, 20.
Mr. P.K. Garodia, the learned counsel submits that the petitioner is going to file an application for amendment of the writ petition. Accordingly, the matter stands adjourned. The writ petition shall be listed only upon such application. Yes.
Well, the district commissioner Kamrup, lordship is present. BC Malad. So in fact, lordship has directed, lordship has wanted to know Malad, why the instruction has not come. Malad, the instruction has, we have received the instructions, we have also prepared the affidavit Malad, it is being filed today. And in fact, Malad, in this connection, already Malad, if lordship colleagues produce the order dated 60, order 2019 at page 62 Malad. Earlier, lordship has directed to pay the compensation. In fact, against that particular order, already a review petition has been filed, review is pending. And Malad, a contempt petition is also filed alleging violation of that. In that Malad contempt petition, Malad, we have already filed our object, the affidavit in opposition. Both matters are pending.
When
And-
did you file the review?
Review was filed in 45 of 2024. Malad. In fact, in the writ petition, they have, at one paragraph, they have indicated. Page 28, para 45. They have indicated, Malad. Page 28, para 45.
Order was passed in 2019.
19, Malad.
You woke up after 5 years.
Malad, in fact, at that point of time, Malad, if lordship kindly comes to page 62, that order was passed, Malad, in that writ petition, no affidavit was filed by the respondent.
Obviously, how can an affidavit be, this type of orders have to be passed, taking into account that you don't provide instructions?
Malad,
I
after,
didn't call the DC just for the any other purpose.
Malad,
It means that what we are facing today is this, that the government council seeks for instructions and the district administration have not done so. In fact, there is another order which I have passed whereby I have asked the chief secretary to take it up with the advocate general. Now, if the persons have been appointed or chosen by the advocate general to be the government advocates, and these persons are not being provided by the district administration, obviously this court has no other way but to ask the district commissioner to be present. We have we have other matters to deal with, but we have to deal up with the district commissioners in every matter like this. Why these instructions are not? Didn't you get a copy of that order? I have marked the copy of the order to you to be
I-
forwarded to the chief secretary as well as so and so.
Got you, I got-
Then why this is happening?
I got that order and. I
No,
have
if you are,
communicated,
you are the senior government advocate, why you are not getting the instructions from the district commissioner? This is a very serious aspect.
Malad, in some cases, Malad, we are.
Then we may have to ask the district commissioner to be, or any person authorized to be present instead of the lawyers.
But, that has been lordship's.
When a notice has been issued, that too, this is the second round of litigation.
But in fact, Malad, in that particular case, lordship has indicated, we have communicated, the chief secretary has already issued direction to.
The-
the DCs.
The chief secretary has to issue
Lordship.
certain directions
Yes,
to the
yes.
concerned district commissioners,
Yes, Lord.
taking into account that you have to provide the instructions.
That has been done.
And this is not the thing for this court or any help to this court, but the
Malad.
fact that you are from the government, so you have to get your instructions. Otherwise, if the district commissioner do not, and there has been two, in that case, I think 2-3 correspondences which have been issued by the government advocate, and the district commissioners completely disregard. This is not how it is to be done.
In fact, that situation has been taken care by the Lanet, the chief secretary has already issued the direction. We have received some instructions. We will also file an affidavit in that case, my lord. Well, particularly in this case, my lord, after my lord, we could not place the records at that point of time when the matter was decided in 2019. But subsequently, we got the records and we found that the petitioner is entitled for only 4 katha, the compensation for only 4 katha land. In that event, my lord, we file a review petition and we have indicated that the amount which the petitioner is entitled, it is already, my lord, the requiring department has given us the amount along with the interest. Petitioner has been given a notice to accept the amount. He did not respond. My lord, this has been brought to the honorable court by filing an affidavit in the contempt petition as well in the review petition. My lord, that is why we have sought for review, because while passing the order in 2019, the lordship has directed us to pay compensation for 3 bighas of land to the petitioner. After perusal of the records, my lord, we found that the petitioner is entitled for only 4 kathas of land. And accordingly, my lord, that amount already we have received from the requiring department. And the petitioner has been given a notice that you come and accept the amount. He did not respond.
No, this is a different aspect.
Lordship.
But the fact remains, I didn't call for on the merits.
My lord.
The problem is that if you are not getting your instruction, we have to ask the district commissioner to be present.
True, my lord. Instruction ought to have come. But
Yes, you are the the district commissioner.
Yes, madam.
Mr. District Commissioner, the thing is like this. If you don't provide your instructions and more particularly take care of the circle officer, Dispur Revenue Circle, the problem with that officer is also that the instructions are not being provided. If the instructions are not being provided, we cannot progress with the matter. Just for example, this is a case. You were not there in the year 2019. On account of not providing instructions or not filing the affidavit, the entire problem has arisen in this matter. If the affidavit was filed at that point of time in those cases, then in that regard, this confusion as to whether the petitioner is entitled to 3 bighas or 4 kathas would have been very well sorted out. This couldn't have been a litigation again in the year 2024. This is a writ petition filed in the year 2024 when notice was issued and there is no instruction provided from the office. It doesn't show it in good light. So therefore, Mr. District Commissioner, obviously, I think you must be very new to this particular, you are a new incumbent to this particular post. But the fact remains that I will request you to provide the instructions to your council so that they can very well file their affidavits or bring the instructions. Because of you or not providing the instructions, the proceeding should not be stalled. And you see, kindly see out here that this is the case of the year 2024. I have directed you only in the year 2026 after a period of more than 2 years. So therefore, if you are not providing your instructions to your government advocates, then obviously we have to ask you to be present in the courts every time, which we do not have. You have. We know that the office of the district commissioner is a very busy office, but we don't like it. So kindly ask your office to do the needful whenever instructions are being sought for.
Yes, madam.
Okay.
Yes, madam.
We do one thing. We list this matter. You have filed your affidavit here?
my lord, we are in
Okay,
the process.
so
We are filing.
we list this matter along with the review petition
Lordship.
and the contempt petition,
Mark.
and you take it up for disposal next
Yes,
week.
Yes. Lordship.
Heard Mr. R.C. Soikia, the learned, Mr. So-and-so, the learned, the district commissioner, Kamrup Metro, is present through the video conferencing link so provided by Mr. J. Hendrick, the learned junior government advocate. This court was compelled to pass an order on 15/7/2026. On the ground that the writ petition was filed in the year 2024 and notices were issued. But there was no instructions provided by the office of the district commissioner, Kamrup Metro, for a period of 2 years. Mr. So-and-so, the DC Kamrup, the district commissioner Kamrup, has submitted that in future, his office would be duly providing the instruction whenever is sought for. The appearance of so-and-so, the District Commissioner Kamrup, accordingly stands dispensed with. Mr. Dina, the learned senior government advocate who appears on behalf of the respondents today, has submitted that an affidavit in opposition has been filed in the present proceedings. Have you filed or not?
We are filing, my lord, in the process, my lord. Just now we are filing.
No, it is not filed so far.
No,
Have you given the copy?
no, we are in the process, my lord. We are filing. Filing during course of the day,
It
my
will be
lord.
filed during the course of the day. Providing advance copy to the counsel for the petitioner. The learned senior government advocate had further submitted that there is a review application pending wherein the order dated, order dated 28/1/2019 passed in WPC number 4507/2013. Wherein a review has been sought for in respect to the order dated so-and-so passed in WPC number 4507/2013. He further submitted that there is also a contempt of proceedings, being contempt case number
87/2020.
of 2020, which is also pending, connected with the present proceedings.
Yes.
It is the opinion of this court that all these, the present proceedings, along with the other two proceedings, are required to be taken up together for the interest of justice.
Yes.
Accordingly, this matter again on 26th of August 2026. In the meantime, the petitioner is granted the liberty to file the reply to the affidavit in opposition, which the respondents are going to file today, as assured to this court. This accordingly.
My lord.
I've not given the personal appearance. I have only said that if you don't file the affidavit, then only, or no decision is taken.
Decision is taken, Your Lordship.
Decision taken. Okay, so then we can close the contempt.
We had not
Yes.
served with the copy of the speaking order, lordships.
Uh,
Only an affidavit has been filed, lordship. We had been served with the affidavit only.
Okay. The present application, this is an application filed alleging willful and deliberate violation to the order dated 10/10/2018, passed in WPC number 7220/2018, whereby there was a specific direction upon the chief engineer, PHE, to consider the representation dated 1/9/2018 filed by the petitioner for making payment of the outstanding dues with interest within a period of 3 months from the date of receipt of the certified copy of the order. Mr. R.R. Gogoi, who appears on behalf of the respondents, Contemner, number?
All the
All the respondent
PHERs.
contemners. Submits that a speaking order has been passed on 30/7/2026. And the said speaking thereby disposing of the representation dated so and so. 1/9/2018. A copy of the speaking order was placed before this court, which is kept on record and marked with the letter X. Taking into account that there has been a speaking order passed in compliance with the order dated so and so, passed in WPC number so and so. This court is of the opinion that further pursuing with the present contempt application would not be in the interest of justice. According, the contempt proceeding stands closed. Before parting with the record, this court observes that the closure of the contempt application on account of the passing of the speaking order shall not prejudice the petitioner, if so aggrieved, to approach the appropriate, to take, to adopt such, to initiate such proceedings as permissible under law.
I'm so glad.
This is the small thing we should have done. What is wrong with your officers?
But they have also done, my lords, in respect of some other petitioners. My lords, other petitioners have already been paid. I have obtained through RTI. They have been paid with the interest parts also.
Obliged.
Obliged, lordships.
And Mr. Gogoi, you know about my earlier order, that order. That order where they have appeared, na, Mrs. M. Hazarika appeared. You know how the matter was dealt with. You know, dealt with in that, where I have given the liberty to you to decide the area, and thereupon if there is any dispute, MSME will look into it.
Lordship, that is Garg Poly Industries. Your lordship's order is of Garg Poly Industries. Lordship, that is
Ah.
the lordships.
So if there is a dispute, bring the dispute so that he can go to the MSME.
Matter of 2019, lords, 6, 7 years down the line has passed, lord. Now this. I'm so blessed.
Should I pass an order to that effect that in view of the delay,
Lordship, that
The
delay being, lords, a bit.
this court further observes that taking into account that the representation has only been disposed of today or by the order dated so and so, which is kept on record and marked with the letter X. Pustak. The dispute as regards the entitlement of the interest shall only be an interest would be counted from the date of passing of the would be deemed to have arisen only on the date on which the speaking order has been passed.
Grateful, my lords.
Right, please, your lordship. Lordship, this matter has become infructuous.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submitted. The writ petition has become infructuous. S.K. Talukdar appears on behalf of the Corporation Department. Accordingly, the writ petition therefore stands closed as it had become infructuous. Yes, what is this? Service is complete.
Lordship?
Service is complete.
Yes, Lordship. Lordship, in this matter, Lordship, the respondent number 4 is the adjacent neighbor of the petitioner, Lordship. Respondent number 4. And he had constructed his building in such a way that he is extended it cantilever over the boundary wall of the petitioner, Lordship. Following which have made a complaint before the Golpara Municipal Board on 17/9/2021, Lordship. Pursuant to that complaint, Lordship, they have issued a notice to the respondent number 4 on 29/2021 for whether there is any permission for constructing his second floor or not, Lordship.
There is an order at Annexure 10
Yes, Lordship.
whereby directing the respondent number 4 to make the rectification.
Yes, Lordship.
Then what happened?
Lordship, thereafter, Lordship,
Then he filed a writ petition.
yes, Lordship.
What happened in that?
The motion states that Lordship, that particular disposition was disposed of with a
He
direction.
had submitted a representation.
Yes, Lordship.
What has happened? The representation has not been disposed of.
Disposal, Lordship, and
Then what?
file subsequently, Lordship.
Annexure 13, page 20.
Yes, Lordship.
Then what happened?
No action has been taken by the Golconda Municipal Board, Lordship. Subsequently, the petitioner have filed a petitioner as well as reminder also, Lordship.
Who is paying for the Gwalpara Municipal Board?
Executive.
Anybody? Why you making the executive officer by name?
Lordship.
Why you making the executive officer a party by name?
When at the first stage, Lordship, they have refused to accept the
Whether
notice.
this executive officer is still there?
Yes, Lordship.
So the Gwalpara Municipal Board does not have a chairman.
Yes, Lordship. Chairman is acted by the DC, Lordship.
Problem which has arisen is this. Because of you making the respondent number 3 by name, government cannot accept notice. Why have you done that?
Lordship.
You should have made the executive officer Gwalpara Municipal Board.
Lordship.
Then the government could have accepted the
When the
notice.
writ petition was filed, Lordship, the earlier incumbent was already been transferred.
Mr. Counsel, the executive, it should we have been the respondent number 3 should have been the executive officer.
Lordship.
By your name, putting by name. The moment you put it by name, the government cannot accept notice. Otherwise, the executive officer of the Gwalpara Municipal Board is a nominee of the government. Isn't it? Mr. Bormon, this is the second round of second proceedings I have seen.
Yes, Lordship.
These problems. You should know, this is not a suit.
Lordship, respondent number 2, I have made party, Lordship.
Understood. That for the respondent number 2, the government cannot, and the respondent number 2 is not appearing. Okay. So for me to pass a direction upon them, very well, I can very well pass a direction to comply with that. But that would not be affected properly. So if you had made the executive officer a party, I could have hold them. The government is already representing them. But you made that mistake.
Lordship, I beg to pay, I filed a separate application for striking out the name of.
Yes, do that and make the executive officer. Once you do that, then they can accept notice. And then they can very well convey it. You have to understand that, Mr. Counsel. Okay, the service being complete as could be seen from the office note dated, office note. As could be seen from the order of the Lozima Court dated 27/3/2026, lists this matter for admission on 24th of August 2026. In the meantime, do that. I'm not here to help you out, but that doesn't mean.
By name, he officer numbered, he was by name, he was implemented. She was transferred from the Gwalpara Municipal Board, long back.
So therefore, now, first of all, you should know how you are doing the matter. You should always make the executive officer a party. Then if you have a malafide allegation against him, then you may make the person by name. But that is not what you have done. It is something like the civil suit. You want to go to the civil court? You want? Close it. File that application which you have done. Item 3 has service upon his complete test. What is this I for?
Lordship, matter become infructuous, Lordship.
Infructuous. Ms. So-and-so, the learned counsel who appears on behalf of the petitioner, submits that the writ petition has become infructuous. And as such, the petitioner is not inclined to pursue with the present proceedings. Taking into account the above, the instant writ petition therefore stands closed as it has become infructuous. Eyes closed. View of the
May please, Your Lordship.
Yes, what has happened? Who is appearing for the respondent DC? Kamrup Rural.
Lordship, I'm appearing.
What has happened? Land, you have got it.
No, my lord.
Why?
My lord, land,
They've
what-
already demarcated.
yes, my lord, demarcated. And land given, but the railway line is there, my lord, that has not been removed, my lord.
What?
In between the land, my land, railway line is there, my lord. to
So how does it
transport-
matter?
my-
Your case was against the FCI.
Yes, no, my lord. FCI line, my lord, to transport the goods from that FCI godown, my lord.
You remove that railway land. It's a very expensive thing. We use it.
Yes, Your Lordship.
You know, so we close it as we got the
my lord,
land.
remaining part, my lord, regarding the rent, whether DC has calculated or not, is not known to me, my lord.
What?
My lord, another direction is there, my lord.
Huh.
Let whereby the district commissioner, Amincome is
put it
further
in,
directed
so
by
it's
himself or
demarcated.
upon his delegation.
Directed either by himself or upon delegation to assess the rental compensation so and so was handed over to the respondent to the date on which he. So the second part has not been done.
Lordship, here we have an instruction. DC has calculated and forwarded to the concerned department, Lordship.
So that it has been done, complied with.
Lordship.
Upon
That is-
receipt of the sales shall make the due payment. And is the FCI a party? No. So then give that.
Right.
We close it.
My lord, let me give a copy of that assessment, my lord.
In it. Mr. Counsel, Government. Mr. Counsel,
Lordship,
you have a photocopy of this?
Lordship.
Give it to him. Heard Mr. M. Saikia, the legal counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the
Dinat,
sole
Lordship.
respondent. Who?
Dinat.
You are Dinat?
I'm appearing on behalf of Dinat, Lordship.
No appearing for Dinat. He is not here, nothing. You are appearing. So-and-so appears for the Mr. So-and-so. The present application has been filed alleging willful and deliberate violation to the order dated 18/12/2024 passed in WPC number 3943/2022. At paragraph 9 of the order dated so and so, this court passed the following directions. So paragraph 9 of the said order being relevant is reproduced. And at paragraph 9 of the order dated so and so, certain directions were passed. The said directions being relevant are reproduced hereunder. From the above quoted, page 17 of Bhagavati, from the above quoted directions, it is seen that the District Commissioner Kamrup Rural was directed to demarcate the land at measuring 1 katha, 10 lechas covered by dag number 1693 of patta number so-and-so of village Sangsari, Moza Sila Sendori Ghopa under Uttar Gauhati Revenue Circle in the district of Kamrup Rural and hand over the possession of the said land to the petitioner. Mr. M. Soikia submits that that the petitioner have been handed over the possession. The second direction which was issued was directing the District Commissioner Rural at Aminga to calculate the rental amount for the period from the date of the land in question, that is 1 katha 10 lechas covered by so and so under Iman so and so, was handed over to the respondent number 4 to the date when the possession is handed over back to the petitioner. Respondent number 4 in the writ petition, to the petitioner. Mr. So-and-so, the learned counsel who appears on behalf of the sole respondent, has placed before this court an instruction dated 21/7/2026, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the amount has been quantified. Where?
And that page 6, second last.
Quantified at rupees 12,86,877. A copy of the said letter, the said communication, which is marked with the letter X, has also been handed over to Mr. M. Saikia. Under such circumstances, the directions which have been passed by this court, more particularly as quoted at paragraph number 9 of the order dated so and so, have been duly complied with. Accordingly, the instant contempt proceedings stands dropped. What is this?
Lord, review petition, review application lordship.
Or
Review of the order passed by this honorable court lordship.
what has happened?
Lordship, earlier petitioner was disqualified by the district commissioner lordship. Petitioner approached this honorable court lordship. Lordship set aside the order and directed the petitioner to appear before the district commissioner. And accordingly, petitioner appeared lordship. Subsequently, this honorable court has laid down law that district commissioner has no authority if the disqualification is prior to acceptance of nomination lordship.
That was on 13/2.
13/2 was directed lordship me to appear lordship, and law was laid down on 23/2 lordship after 10 days lordship. I did not raise, I only raised lordship without hearing lordship that part. Earlier occasion lordship, my contention was that order was passed without giving opportunity lordship, but subsequently lordship with canon of judgments lordship already held that district commissioner has no authority if qualification is prior.
We
to-
can't review that. I
Lord.
think the district commissioner should be informed about that and then close it. We therefore observe to that effect. We close this corner review petition with the observation to that effect that the law now is well settled.
Lordship.
That the district commissioner does not have jurisdiction to take note of matters pertaining to disqualification which arose prior to the submission of the nomination. And as such, the district commissioner shall, while adjudicating the proceedings or
Lordship.
taking further the proceedings,
Lordship.
shall duly take note of that judgment in Aisa Khatun. I
Lordship.
think with that only we can close. So this is an application for review of the or judgment order dated. Where is the order?
Lordship, page 53 lordship. 53 lordship, annexer B lordship.
Order dated 13/2/2026. Passed in WPC number 738/2026. Whereby this court, on the ground that the speaking order dated 10/12/2025 was not passed by giving the petitioner an opportunity of hearing, had set aside the speaking order dated 10/12/2025 and directed the District Commissioner Kachar to pass a speaking orders as permissible under the Assam Panchayat Act 1994 as well as the rules framed therein under by giving an opportunity of hearing to the petitioner. The petitioner herein have sought for review of the said order dated 13/2/2026 in WPC number 738/2026 on the ground that subsequent to the said judgment order, this court in various writ petitions, including in the case of Isa Khatun versus State of Assam and 5 others reported in so and so, had held that in respect to disqualification which stood prior to submission of the nomination paper, district commissioner could not have exercised jurisdiction to, in terms with section 111 bracket 2 B
F lordship, child marriage, F lordship.
of the Assam 111 bracket 2 of the Assam Panchayat Act 1994. This court duly takes note of the settled principles of law that seeking a review of an order passed by this, a review of a judgment and order passed, a subsequent decision so passed would not render the order which has been passed earlier, judgment or order passed earlier, an error apparent on the face of the record. It would also not come within the ambit of the jurisdiction of this court. While exercising the power of review, to review an order passed on the basis that at a later stage, this court or any other court had passed an order which goes contrary to the order which had been passed by this court. Under such circumstances, it is the opinion of this court that this is not a fit case for exercising the review jurisdiction. Be it as it may, this court also duly takes note of that in the judgment and order, in the order dated so and so, 13/2/2026, passed in WPC number 738/2026, this court had categorically directed the District Commissioner Kachar to pass a speaking order as permissible under the Assam Panchayat Act 1994 as well as the rules framed therein under. Under such circumstances, the interpretation so given by this court interpretation so given to section 111 read with rule 62, section 111 of the Assam Panchayat Act 1994 read with rule 62 of the Assam Panchayat Constitution Rules 1995. In the case of Isa Khatun Supra, has to be duly taken note of by the District Commissioner Kachar while passing the speaking order. It it may not be out of, it may not, it may not be out of place at this stage to observe that in the case of, in the judgment rendered by this court in the case of Aisa Khatun Supra, this court had categorically held that the district commissioner does not have the jurisdiction in exercise of the powers under section 111 bracket 2 of the Assam Panchayat Act 1994, read with Rule 62 of the Assam Panchayat Constitution Rules 1995, to exercise jurisdiction in respect to the disqualification which was in respect to a pre-existing disqualification prior to the submission of the nomination paper. This aspect, the learned district commission, the district commissioner Kachar shall duly take note of while passing the impugn order. I dismiss by allowed. Because if I do that, I review, it will open a Pandora's box. I can't. Yes, what is this IA?
This IA is filed to strike out respondent number 10, Your Honor, name of respondent number 10.
An application filed by the applicant, who is the petitioner, for striking out the name of the respondent number 10. So, the respondents herein do not object to the same. Submits the learned counsels appearing on behalf of the respondents do not object to the same, and submits that such striking off shall be at the risk of the petitioner. Taking into account the above, this court therefore strikes out the name of the president and secretary. Respondent number 10. The respondent strikes out the respondent number 10 from array of parties in the accompanying writ petition at the risk of the petitioner. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court. The registry, on the basis of the present order as well as the memo of parties, make necessary changes in the cause title and update the same in the CIS. I stands closed. Okay. What is your matter? Argue. What? No. You cannot. This is the case.
Revenue is directed to.
On the last occasion, we have placed the instruction, Lordship. Lordship has fixed the meter on 2nd of November, Lordship.
Yes, what happened to the representation?
On the last occasion,
What happened to the representation is not, I've given
yes,
8 weeks. Na?
we
I've
have-
given 8 weeks. Taking it next, taking to main nalage. I've directed the matter to be listed on 211. Yeah,
May I please the Lordship?
yes, Mr.
My lord, small correction is required. Here is the case is that petitioner specific claim compensation against Jirat value. Learned government at the time of hearing submitted, that value compensation has been paid to the landowner. And that's why Lordship disposed of the matter in referring the 3G4, 3H4 competent authority.
Okay, then
Then my paragraph 2 Lordship is appeared, page 37. The grievance of the petition here is that landowners have been paid the compensation, whereas the petitioner have not been paid compensation for the land. It will be Jirat Lordship. And my further submission, government submissions may be recorded that as per instruction received by him, that compensation is paid to the Jirat. That is required to be inserted, Lordships. That is the prayer.
so what do you want?
But instead of land loss, it should be Jirat losses. And once further that
You are
submission,
not asking for the land compensation.
compensation for Jirat. Landowners got the land compensation, lordships. But Jirat compensation, two of the, here is the six persons are also owners as well as Jirat. They are
Not the owner.
6 persons are owners, others are lessees.
This type of, I think we should recall the order and dismiss your petition.
My lord, now here is the, I am the lessee.
Why you are bringing all these other people out there? I think we should recall this order. What do you think? Smart. You recall it.
My lord, here only I am paying for only.
No.
That
you
lord.
cannot. We recall that because it is a case of review, what you are asking.
No, my lord, land
it is
here
a case
appear
of
only
review.
land lordships.
Mr.
My lord,
If you, the matter is a case of
My-
review.
I understand losses, but here appear land also. Jirat.
IR 97 Supreme Court says that in a dispose of matter, you cannot file an interlocutory application. The matter, that judgment has been followed fully by the Supreme Court.
Had there been a typographical error, then also it's something different, madam.
I may be
152 had been come.
allowed to file review losses instead of issue losses. Review losses, that liberty may be granted.
The learned counsel appearing on the petitioner submits, applicant submits that he may be permitted, though the instant with the liberty, a review application, taking into account the post with withdrawal, the petitioner would be at liberty to file the review subject to the same principle under law.
Losses. Obliged.
What are these?
This, I've been preferred, your lordship, for condonation of 81 days delay, your lordship,
For what?
for preferring restoration petition, your lordship, to restore
When
the
did it get dismissed?
TNFP, your lordship.
Yes.
Please, page number 16, your lordship.
In the miss case for.
My name has not been reflected in the
order.
cause list.
Miss case then.
Your lordship, I'm the new engaged counsel in this writ petition, your lordship. My name been not reflected in the cause list, your lordship, for which your
You
lordship,
get engaged.
lordship.
Did you get engaged?
Was in the year 2025 only, your lordship.
You impose a
Here,
cost.
your lordship, this was,
Here we have to impose a cost. What is your case about?
your lordship, recovery of subsidy amount, your lordship,
No.
present, your lordship,
Recovery of subsidy.
subsidy, your lordship.
Well, you have money. Will do so, provided you pay 50,000. Okay, cost.
Lordship, no, my.
What is your
lordship,
recovery
no,
amount? What is your
30%
recovery
of
amount?
the, 30% of the loan amount, your lordship. The
How
third,
much?
it was some 1 crore,
How
your
much?
lordship. Out of 1 crore, 30%, your lordship. 30% of the
1,000 cost.
lordship, it was,
So not interested.
also my apology, but lordship,
Oh, well, it's not. You have been recently engaged.
not recently, your lordship, in the year 2025, but new engaged council name is not there in the cause list, your lordship.
Whose name was there?
The earlier councils, your lordship.
When did your name enter?
It is in the year 2025, country, he called the exact date, your lordship, when I, and
Find
in
the
this
miss
case,
case.
lordship, me, lordship.
Case 52.
Lordship, because it was earlier also dismissed, your lordship. That was restored, your lordship. That was restored, your lordship. Again, your lordship, the same thing happened, your lordship. My name is not there, your lordship. The WPC has been listed for twice, your lordship. But again, my name has not been listed, your lordship. The earlier engaged council name is there, your lordship. For that reason, your lordship,
Where is the cause list?
cause list I have not.
On the
annexed.
day on which it was got dismissed. Where is your cause list?
Date of cause list, my apology, I have not annexed, your lordship, with this.
In the cause list.
Lordship.
Because we are not satisfied with your.
Lordship, I'll bring the cause list, your lordship.
Or else pay 50,000.
No, lordship, I'll bring the cause list, your lordship.
When the new council was engaged, that also not been pleaded.
When she was engaged, nothing has been pleaded, my lord.
I will bring the, all the
Whether-
cost list, your
My
lordship.
lord,
Uh,
Mrs.
50,000 is good.
M. Decker, I think is our colleague,
Lordship.
same chamber.
No, not the lordship. Our new council's name is not in the cost list, your lordship. So lordship may kindly give a date, your lordship. I will bring all the cost list, your lordship, by filing additional affidavit, your lordship.
The materials on record do not satisfy this court. Do not prima facie satisfy this court. As regards the grounds and reasons which have been mentioned in the application for restoration. Ms. So-and-so, the learned counsel who appears on behalf of the applicant submits that some time may be granted to file an additional
Lordship.
matter only upon such additional affidavit.
Much obliged, lordship.
Two options.
Lordship, I filed an application for additional documents. This matter, your lordship. Steps for service were taken on 2nd of June, your lordship. It is our belief that the respondent is deliberately evading service, your lordship.
Who?
The respondent here, your lordship.
Who is the respondent?
Your lordship, if I may explain, your lordship, the respondent and the petitioner, they are a part of a joint venture. This joint venture had successfully Lordship, this joint venture had successfully taken a NF railway tender, your lordship. The petitioner is the lead member in this JV, your lordship. There was a dispute regarding the operation of the bank account of the JV, your lordship. The Honorable Court had settled this.
What happened to the writ petition?
Your lordship, the writ petition was disposed of, your lordship. It was disposed of on basis of an assurance by the respondent here, your lordship. Page 20, your lordship, the assurance is recorded before the honorable, that was made before the honorable court, your lordship. As per the assurance given, the respondent had undertaken that he will sign the checks for the JV, for the amount to be withdrawn from the JV account, your lordship. Now, your lordship, in December, the respondent has given stop payment instructions to the bank, your lordship. So the payment cannot be withdrawn from the JV account, your lordship. I am the lead member, your lordship. I have to face the brunt of getting
What is your name?
Dromos, your lordship. I'm DECPL.
The problem arises because this court have exceeded its jurisdiction. A writ proceeding where a writ should have been issued, the writ has been, these observations are being made and you are. What is the direction? There's no direction here. Considering the submissions made by the counsel for the parties and keeping in view that it is an admitted because of they want the JV account. This court is of the view that at the time of withdrawal of money, all the members of the JV should sign the check.
Your lordship, para 11 of
Now
the.
wait.
Yes.
First of all, whether there is any withdrawal? No.
Because your lordship, the respondent.
That's true.
Yes, sir.
No withdrawal.
Yes, your lordship.
In this regard, the respondent number 1 shall ensure that they are always present and ready the check for withdrawal of money in as much as the very purpose of opening a so and so. This could not have been exercised by this court.
Your lordship.
Or you go to that judge who passed it. This order is a writ being issued to a private person.
Your Lordship,
Very clear.
I've,
And now what is being done out here is that you are asking this court to implement. Very difficult.
Your Lordship, if I may just, one small submission here, Your Lordship, I have annexed additional documents, Your Lordship. The NF Railway has given me 1 week time to show the progress, Your Lordship. Your Lordship, I have, very expensive equipment which is already at the site. These are wires, transformers, which are already there, Your Lordship. To proceed with the work, Your Lordship, this bill, this RA,
No,
which was
Mr. Counsel. Problem lies is this. What you are asking is for a private person. This order could not have been passed by this court. Very difficult.
Lordship, nonetheless, Your Lordship, it is only the respondent who has given the undertaking, Your Lordship. The Railways has already given the payment in the JV account, Your Lordship. The matter here is to
Do
withdraw.
one thing. Better ask for modification of this order. Before that. Saying that this has happened. Now because of that, ask for a review. That is the only way out because now you are tied because of that order.
Absolutely,
No.
Your Lordship.
Only way is get out of that order now because he's not complying with it. We keep this contempt pending. It will show that the respondent number 1 is not complying.
You know,
now you file some order or review or recall or something or some direction to the effect, asking that particular court to do it. Then you give us the handle somehow. Then we can very well say that,
Obliged.
okay, you can, if he is not cooperating, then obviously you can do it because otherwise the work will be harmed.
Your Lordship, but
That is the only way out.
Your Lordship, my humble submission here, Your Lordship. Lordship, I have attached documents, but recently I have received another notice from the Railways, Your Lordship. It is a very strict notice on me.
I'm not understanding. Can I pass an order directing him to sign it
Your Lordship,
or to be present? You are not a counsel here from Gauhati.
I'm from Chandigarh, Your Lordship. I'm
Yes. 3 years of practice you have. Because it matters most probably.
yes, Your Lordship.
But they are now here, the private respondent.
Your Lordship,
This
but
direction was absolutely for the private respondent.
yes, Your Lordship.
Problem lies with you. This court to enforce that it becomes very difficult. So therefore, you need an order by which this order is modified to the extent that if he does not cooperate, then you can very well exercise your own right. You need an order to that effect, Mr. Counsel.
Yes, Your Lord. Your Lordship, maybe I kindly present the last notice that I have received from the Railways, Your Lordship. It just gives me a week's
No,
time.
Mr. Counsel, I cannot pass any order to that effect. I mean contempt. You have the contempt jurisdiction is very limited.
But Your Lordship, they have absolutely given an undertaking and gone back.
Can I ask them, okay, initiate the contempt proceedings against them. Let us see whom you have now made.
Your Lordship, it is KTC, Kagamba Transmission and Construction.
Now tell me one thing. Can a company
Lordship.
be held in contempt?
Your Lordship, the directors may be held in contempt because the undertaking was given specifically before this honorable court. Your Lordship, the undertaking being that we will sign this check.
Thing was you have to make this company, the proprietor, or whoever it is, a party. How can there be a contempt proceedings initiated against a company or a firm or something? This is a non-entity. No, it's not a juristic entity. He's a juristic entity, but not a natural person.
Yes, Your Lordship.
So how can I initiate a contempt proceedings against them? Tell me.
Yes, Your Lordship.
Possible. Can there be a contempt by a person, by a non-natural person?
I'm totally before Your Lordship for
No,
this.
you cannot be. But my question is it permissible? You are from Chandigarh. You have good access to all this, in this technological, law, all these things. But tell me, can it be permissible to initiate a contempt proceedings against a non-natural
Competent.
person?
Lordship, I can get precedence to the effect that the directors may be
It is they who have to be made a party.
Lordship, I've named the directors in the petition. I've named them in the petition.
Whom should I punish?
Your Lordship,
Whom should I punish? Tell me.
Your Lordship, the correspondences are issued by the managing director, Your Lordship. Your Lordship may kindly have. Your Lordship, in the memo of parties, it says represented by its
I will hold the
managing partner, Your Lordship.
Khagemba transmission construction.
Through its
Hold
managing,
the respondent guilty of contempt, direct contempt to forthwith purge the contempt. What is this?
Your Lordship, my humble submission here being that, Your Lordship, this was a very clear undertaking that it was given, Your Lordship. I'm the lead member, Your Lordship. I have given the bank guarantee, Your Lordship. If tomorrow anybody is blacklisted, I will be blacklisted, Your Lordship. All my equipment is at the site, Your Lordship. I was in the writ petition, Your Lordship. We did the writ petition.
That doesn't answer my point. My point is, how are you going to maintain this contempt? If it was me, I would not have issued notice also in this case. Lucky enough, somebody has issued notice. We have kind judges out here in Gauhati.
I'm very obliged, Your Lordship.
So we dismiss it.
So, Your Lordship, if you kindly give me an
No,
opportunity, I will file a review.
absolutely.
Your Lordship was
This
saying-
cannot be a contempt. We dismiss the contempt. How can there be a contempt be filed against a non-natural person?
Lordship may grant me an opportunity to amend the memo of parties. I'll
Mr.
plead the
Counsel,
file.
sorry. I'm going to dismiss it right away. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The present application has been filed alleging willful and deliberate violation to the order dated 28/8/2025, passed in IA Civil 1963/2025, arising out of title suit number 974/2025. It is the case of the petitioner herein that there was an undertaking given by the respondent herein, that the respondent would be present and ready to sign the check for withdrawal of money. And this undertaking is sought to be violated, has been violated. This court have duly perused the application and is of the opinion that the instant application is not maintainable, inasmuch as there cannot be initiation of contempt proceedings against a non-natural person, that is, accordingly, the contempt proceeding stands closed. Liberty, however, is given to the petitioner to file appropriate application. If so it stands closed, stands dismissed. So the dismissal of the instant petition shall not preclude the petitioner to file application initiating contempt proceedings against the persons who are responsible and conducting the business on behalf of the respondent.
Highly obliged.
That is why he is not accepting notice, Mr. Counsel. Problem lies there.
I have mentioned the managing partner in the petition, Your Lordship. I have mentioned him by name, Your Lordship.
Okay, should they stack up the liberty?
I'll be highly obliged, Your Lordship. Highly obliged, Your Lordship.
I closed.
Service complete.
Service complete.
Yes, my lordship.
Matter pertains to?
Matter pertains to my lordship, the petitioners fixed deposit amount 6.44 lakhs have been prematurely liquidated by the respondent number 2, my lordship. And thereafter, my lordship, we have filed a complaint before the respondent number 2. And
What happened?
my lordship, what happened here, the petitioner's 6.44 lakhs amount of money, my lord, to deposit account, my lordship. The particular money was fraudulently transferred to some other account, my lordship. And respondent number 2 initially phone call to the petitioner and informed that particular amount, did you done any communication for any transformation, OTP has been come. And he specifically denied it that I have not done it. Thereafter, he filed a complaint that I have not given any OTP number to anyone. This particular amount have been fraudulently transferred to some other account, my lordship. So thereafter, I filed a complaint before the respondent number 2, respondent number 1.
I'll do affidavits.
My lordship, let them
For the
file an
first
affidavit.
today.
Huh?
For the first time, I'm appearing today after notice.
Who is the person responsible?
That bank is the IndusInd Bank.
In the land.
Respondent 2.
IndusInd Bank. So you had the account there. And who appears for HDFC?
My lordship,
There are so many parties. HDFC idea. You had only one amount where?
my
In
lordship,
which
my
account?
have been Indus Island Bank and the HDFC Bank, 2 account, my lordship. 2 fixed deposit account, my lordship.
All these 2 amounts have been siphoned off.
Yes, it is fraudulently transferred to some other account, some other people account, not my account, the petitioner's account, my lordship.
You have filed an FIR also.
Yeah, I filed an FIR also, my lordship.
So who is the executive vice president? Why are you making him a party?
7.
My executive vice president. Actually, my lordship, this particular case has been engaged by the other advocate, my lordship. This particular case, my lordship, is there another thing, an advocate, senior advocate is there, my lordship. So today they're supposed to file an affidavit and instruction have to come. So I'm appearing, my lordship.
From the office note dated. What about the service upon the others?
It has been served, my lordship. Order, my lordship, kindly say the last order, my lordship.
What about the others?
Notice has been served, my lordship.
1, 2, and 3 is these.
I'm appearing for 1 bill.
Okay. What about 2 and 3? What about 4 and 7? 4 and 7? This is wrongly shown. Mr. Sharma, you don't accept notice for respond number 4.
I am for 5 and 6.
5 and 6. The order says 5, 6, and 7. It can't be.
No, only 5 and 6.
The order is wrong. A. Hussain, the learned counsel has entered appearance and accepted notice for respond number 4. Who is A. Hussain? This service, Mr. Counsel, is not properly done. It appears to be wrong. So, as regards respond number 2 and 3, he only appears for 5 and 6. 7 also there is nothing because 7 is some person in Andheri. Mr. H. Sharma, the learned counsel, if state counsel submits, learned additional senior government advocate submits that there appears to be some mistake in the order dated 3/6/2026, wherein it is mentioned that he represents the respondent number 5, 6, and 7. The learned counsel submits, learned additional senior government advocate submits that he only represents the respondent number 5 and 6. It's good. এই এদিকে আরো এখন কাউন্ট করছো could also include the office note. Wherein it is seen that the service have been affected upon the respondent numbers 1, 2, and 3. And so appears on behalf of the respondent number 1. However, there is no service which have been affected upon the respondent number 4. 4 and 7. The counsel appearing on behalf of the petitioner is directed to take fresh steps upon the respondent number 4 and 7 by way of speed post within 3 days. This the matter upon service being complete upon the respondent number 4 and 7.
Deeply obliged.
As per Lozima Court's direction, service has been completed on all the respondents.
What is the matter about?
But see what happened, we file a complaint before the RERA. Is 23 lordship, the proceeding is pending. But see, all the orders been passed, but roving and fishing inquiry is going on. No final order has been passed. We file this petition under Article 226. With the prayer that direction may be issued to the Real Service Authority to dispose of my petition within 2 months. And as per section 29(4), the proceeding is to be completed within 60 days also. If not, let then taking order is to be passed.
You have filed a complaint before RERA.
In 23, in 23.
Huh?
2023.
What is that?
In 23, we file a complaint before the annexure 1. But
Then?
till date, it has not been disposed of, although different order has been passed. Lordship, fishing and roving inquiry is going on. No proceeding has been disposed of. And Lordship 29(4).
Who are you?
I am the complainant, Lordship. My prayer before Lordship, a direction may be issued to the authority to dispose of the complaint within a specified time period.
The actual contest is between the complaint, the petitioners and the respondent number 2 and 3. I am the new builder in therein, the erstwhile builder, and he's the allottee under the erstwhile builder. I pray for respondent number 4. Hearings have been concluded many a times, my lord. On last several occasions, we have been asked to file affidavits on affidavit. And in fact, hearing on all sides were completed. My lord, before the Real Estate Regulatory Authority, my lord, the PO.
But
However,
Lordship,
my lord,
no order has been passed till date. Lordship.
What is the time schedule to pass the?
Within 60 days, section 29(4). Section 29, subclause 4.
Huh?
29, subclause 4.
Of the authorities.
Lordship. Question which came up before the authority shall be dealt with the expeditiously as possible, and the authority shall dispose of the same within a period of 60 days from the date of receipt of the application. Then provided that where any such application could not be disposed of within said period of 60 days, the authorities shall record its reason in writing, not disposing the application within that period.
So you are only aggrieved by non-completion of the complaint.
Yes, Lord.
To direct them to complete it as expeditiously as possible and
Lots.
preferably within 60 days.
Lots.
Heard Mr. S. C. Kyle, the learned counsel, hearing on behalf of the learned senior counsel, assisted by so and so, appears on behalf of the respondent, appears on behalf of the petitioners. Mr. H. Sharma, the learned senior government, on behalf of the respondent number one. Mr.
A. Bhatra for respondent number 4.
Appears on behalf of the respondent. Only 4.
Yes.
What about the others?
Your Honor. Your Lordship, I am appearing for respondent number 5 and 6.
Ms. So and so appears on behalf of the members 5 and 6. Also seen from the office note dated 13/7/2026, there is service upon the respondent numbers 2 and 3 have been affected. Present petition has been filed being aggrieved by the delay in disposal of the complaint filed by the petitioners, which have been registered as RERA/Assam/COM/2023/18. This court duly takes note of section 29(4) of the real estate mandates that the complaint so filed that questions which come up before the RERA shall be dealt with as easily as possible, and the authority shall dispose of the same within a period of 60 days of the application. It is also mentioned that the circumstance such the authority is not in the position to dispose of the same within the period of 60 days. Due reasons shall be recorded. Taking into account the limited grievance to the effect that the RERA authority, that the learned RERA is delaying the disposal of the complaint. The opinion of this court that the writ petition can be disposed of, thereby directing the RERA decide the complaint, particularly when it was filed in the year 2023. Accordingly, this of the instance, by directing the RERA to dispose of the proceedings being RERA oblique the complaint oblique the RERA oblique Assam oblique COM 2023/18. Copy of the present order is served upon a person of RERA.
Much okay.
To give.
May I please, Lordship? I want to implement two of the bank respondent number 6 and 7. Bank account has been freezed.
You want to implement who? Six and seven.
6 and 7.
Branch manager.
Branch manager. Bank of India and ICICI Bank branch manager.
Application filed for In the opposite party number 6 and 7, the accompanying writ petition. Taking into account the grounds which have been written in at paragraph number 3, 4, and 5. It is the opinion of this court that the opposite party number 6 and 7 are necessary parties for an adjudication of the accompanying writ petition. Accordingly, the opposite party number are arrayed at number 6 and 7, the accompanying writ petition. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of the registry of this court, and the registry shall, on the basis of the present application, present order, as well as the memo of parties, make necessary correction in the cause title and update the same within in the CIS. I stands disposed within 7 days. To notice upon the newly impleted respondent number to petition. Respondent number 6 and 7 by speed post within 3 days. The state notice is made returnable on September 2026.
However, I may be allowed to take fresh step on respondent of 4 and 5 also. 4 and 5 also I need to take fresh step. Because
Counsel appearing on behalf of the petitioner further submits that he wants to take fresh steps upon the
and
same shall also be done by way of speed post.
also want to file one additional affidavit to tell on record. Additional affidavit.
The granted the liberty. You file later.
Okay.
Because otherwise what will happen is
Okay.
once you file again the notice.
Right. I will file later.
You file later. In the meantime, let us see the steps up. Yes.
Reason for impleadment, my lord. On the last occasion, the standing council submitted the Ministry of Jal Board and Brahmaputra Board would be necessary. Accordingly, my lord, this has been filed.
Leading the opposite party number 6 and 7 parties to the writ petition. To account the stand which have been taken. The Department of the Government of Assam, the opinion of this court that the opposite party number 6 and 7 are necessary parties to the accompanying petition. Accordingly, the opposite party number 6 and 7 are arrayed as respondent number 6 writ petition. The petitioner, counsel for the petitioner is directly parties before the registry of this court 7 days. Registry on the basis thereof the correction of the cause titles and update the same. The basis of the present order as well as the memo parties shall update and make necessary correction of the cause title petition and update the same as highest. 8 areas. Mr. K. Gogoi accepts notice on behalf, issue notice upon the respondent number 6 and 7. Mr. K. Gogoi, the learned CGC, accepts notice on behalf of the respondent number 6 and 7. Extra copies of the writ petition is served upon the respondent. Extra copies of the writ petition along with the affidavit. So you file affidavit. Extra copy of the writ petition be served upon him within 3 days. The respondent number 6 and 7 is directed to bring on record this affidavits on or before 15th of September 2026. the matter on 18th of September 2006.
On a similar matter, same one.
I plead with that. My lord, IA has been filed for impeachment.
Impeachment of whom?
My lord, your lordship kindly see page 17, my lord. Prior portion, my lord. Mrs. L. Sweetie Sang, he should be implemented as opposite party number 7, and Dash Kartik as 8, Pradeep Umung as 9, Vikas Medi as 10, Suraj Bardoli as 11, my lord. As per my lord, this application has been filed as directed by this honorable court in earlier occasion. Accordingly, my lord, the name of the new incumbent has been supplied by the, my lord, learned council, government side, my lord.
The direction passed.
My lord, your lordship kindly see page 33, my lord, last page, my lord. That's when the submitted the process for consideration.
This is for settlement.
Yes, my lord.
What has happened?
My lord, the process under, my lord, they are taking process, my lord. But it has not been completed. In the meantime, my lord, a new incumbent has come, my lord.
You claim to be the owners of the land. That those have been shown as government.
Yes, my lord. My lord, what happened, my lord, my lord? We are in possession for last, my lord, 67 years.
Possession is different. My case is are the owners of the land.
Yes, my lord, exactly, my lord.
Those title documents have not been taken into consideration.
Yes, my lord, exactly, my lord.
This is an application filed for pleading the opposite parties numbers 1 to 5 as respondents of the contemners in the accompanying contempt proceedings. The filing of the present application has been necessitated by the on account of the order passed by this court dated 24/6/2026 in concase in the accompanying contempt application. Taking into account that the present incumbents who have been arrayed as opposite party numbers 1 to 5 would be necessary for the purpose of effecting compliance to the order dated so and so. Order dated The order dated 8/2/2024 passed in WPC number 250/2023. This court states the opposite party's number 1. Respondent numbers
7, 8, 9, 10, and 11.
7, 8, 9, 10, and 11 to the accompanying contempt application. Officer कौन लगेगा the counsel? Take the line to legi go. I will make the necessary correction on the basis of these orders and so.
May I submit, Lordship? Lordship, in this case, Mrs. L. Sweetie Sampson's designation is wrongly referred, Commissioner and Secretary, but she is holding the post of Additional Chief Secretary.
To notice upon the আগৰ order to এটা লিখি দিব হা I brought to the that the mission of one have been mentioned as commissioners to the Revenue and Disaster Management have been the Chief Secretary, the government of Assam department. Episode that's the while filing the memo party will duly take note of the said aspect. The correct that's the opposite party now. Sir, this upon the newly pleaded on the numbers 7 to 11.
Yes, madam.
Steps be taken by way of speed post. The newly pleaded respondent numbers 7 to 11. Turnable on 18th of September 2026. Steps be taken by way of speed post within 3 days. Here, 46.
My lord,
Yes, what is this?
my lord, your
Mr.
lordship.
Borua.
Yes, my lord, I have.
Not fancy, madam.
There's nothing to that effect.
My lord, I understood. I think I understood.
Mr. Borua, you don't leave aside Mr. S. Bora. Isn't it?
Yes.
For some reason or the other, and I think this is a matter where GMC has no business, I suppose.
Yes, sir.
Isn't it? But you want Mr. S. Bora to be.
My,
Yes.
my lord,
Now,
your
please
lord,
granted to the petitioner to bring on record in document to show that the petitioner land is covered by so and so.
my lord, I have some answer, my lord, I understood. My lord, this plot of land, your 261 has 4 bigha lands, my lord, 2 bigha something.
No, 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 you are to show that because this is the 1381.
Yes, that,
Your categorical case on the last occasion
My
when
lord.
was that your land has been taken away
yes,
without payment of compensation.
yes, my lord, that was my case.
They categorically file an affidavit that the land which have been taken away is 1381. Your land was a part of a particular 243,
261, 1035.
206,
1035 was the
61,
new
which
term.
is 1035.
Yes, my lord.
And therefore I asked you as to how you come within 1381.
My lord.
You have failed, so you have no case.
So, my lord,
Close it.
yes, with liberty, my lord, one thing, my lord, I may,
Go to the civil.
no, my lord. All right, my lord, you can, your lordship may pass an order, so I may get liberty to approach inappropriate.
if I can buy partition or anything, I can show, then I will approach. Otherwise, at this stage, I cannot show that my 2 acres of land is a part of this road or not. But this, my lord, page 42 is clear about that, my lord.
That letter of that officer could not help you.
Because
Your entire
it-
basis that your land has been in under occupation of the PWD or whoever it
Yes,
is,
yes.
is only on the basis of a letter written by some officer.
Inquiry report.
Inquiry report, somebody has done it, but they have filed an affidavit that to that effect
Yes,
that it is
they are
free in
right.
1381.
Yes, they are
Therefore,
right.
I gave you the opportunity.
Yes. Now, partition.
Now the question is, do you want a dismissal or a withdrawal?
No, withdrawal, my lord, with liberty, my lord, because if we can prove, then we can approach. Or if we cannot prove, well, it's out. Because it is admittedly
And with a further undertaking from Mr. M.J. Bolwa that under no circumstances later on, for each matter, don't bring Mr. S. Bora. Unless you have some good connection with him, that every matter you bring him so that he is also benefited by appearing on behalf of Aya. He has no business at all. GMC had no business at all. Didn't it?
No business, my lord, that, my lord.
Heard Mr. M.J. Borwa, the learned counsel, appearing on behalf of the petitioner, Ms. N. Bordloi, the standing counsel of the Revenue Department, Mr. S. Bora, standing counsel of the GMC, and Mr. M. Bhuya, the standing counsel of the PWD Roads. Mr. M.J. Borwa, the learned counsel, submits that taking into account the stand which have been taken by the respondent authorities to the effect that only the land covered by DAG number 1381 bracket new have been, isn't it, madam?
Yes, your lordship.
81 oblique new have been used for the purpose of construction of the road. And disputed questions arise as to whether it is the land of the petitioner which have been wherein constructions have been carried out. The petitioner would not like to pursue the present proceedings. He, however, submits that the withdrawal of the instant writ petition should not affect the rights of the petitioner to approach the competent court of civil jurisdiction, if so advised.
Civil or any other forum, my lord. I file a partition, demarcation, my lord. If it's on demarcation, good results comes, I can approach also. Then authority by filing demanding is because at this stage I cannot
For
show.
the appropriate court of civil jurisdiction or the appropriate forum,
My
if
lord.
so advised. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Liberty is granted to the petitioner to approach the appropriate forum, if so advised.
Yes, sir.
Yes, your lordship.
May I please, your lordship?
Stated instruction, Mr. Gogoi.
Kindly page the last page, lordship.
In view of the above.
Last 2 paragraphs, lordship.
Then what is your case?
It's regarding misappropriation of funds, Lordship, for the year 2001 and 2001 to 2006, Lordship, in the Gaon Panchayat of, for the development works of Cheragi Gaon Panchayat, Lordship.
From 2005 to 14 also.
Hmm?
From 2005 to 14 as per their payrolls.
Normally, this court would have otherwise permitted you, Mr. Gogoi, but does it take 7 years?
Lordship,
7 years.
what is the otherwise, Lordship? as
And
per the
he says that he can complete within 3 months, and it has taken 7 years.
last chance is because they are paying, Lordship. Otherwise, Lordship, some documents they have sought for certain documents, Lordship. And work completion certificate, and other things, Lordship.
But
they-
does it take 7 years?
That cannot be. It's a, Lordship, purely negligence on the part
I
of
think
the.
we asked this officer should be removed, being some other officer, because he doesn't seem to be.
Negligence on their part.
Display board everywhere about the competence of this type of officer for disposal of.
Probably in the meantime, Lordship, the.
Yes, that the government does not want this thing to be done. No quarrel. And the regular inquiry started in the year 2016,
Last-
10 years.
Lordship, let me give a last opportunity.
We ask the DGP to do the needful,
Lordship,
not how you do it.
Lordship.
Submit an affidavit. The present petition has been filed by this court, filed by the petitioners before this court, seeking an inquiry into the irregularities, malpractices, corruption in execution of the government development schemes for the year 2005 to 2014 relating to Cheragi Gaon Panchayat in Karimganj district. It is the further case of the petitioner that there was a direction passed by this court, by the learned division bench of this court, in the order dated 8/4/2015, passed in PIL number 21/2015, to conduct an inquiry. And then also, nothing has been done. It is seen from the records that on 22/3/2018, notice was issued. When the matter was taken up by this court on 27/2026, an instruction was placed before this court that the inquiry was going on. Taking into account that the instruction so placed was almost a year back, this court directed the respondents to produce an updated instructions. And an updated instruction has been placed before this court by Mr. K. Gogoi, the learned additional senior government advocate, which is kept on record and marked with the letter Y. From a perusal of the said instructions, it shocks and surprises this court that the inquiry was initiated in the year 2016. As would be available, as would be seen from the number of the inquiry, the registration of the inquiry being regular inquiry number 4/01 2016. Ten years down the line, the inquiry officer had mentioned that there are voluminous documents for the span of documents involving 12 suspected officers during the period from 2005 to 15. And as such, the inquiry could not be completed. Without going in, without a mere cursory glance at the instructions itself shows that either the inquiry officer is incompetent or the state of Assam is not inclined, or the authorities can respond, and authorities are not serious in the said inquiry. The said opinion of this court is based on the fact that examination of records for a period from 2005 to 2015 cannot take a decade for carrying out an inquiry. The Director General of Police, being the highest authority in the police administration, is directed to file an affidavit as to why the inquiry officer is taking a decade for deciding the said inquiry, for submitting a report in the said inquiry. This matter on 16th of September 2026. The affidavit be filed by the Director General of Police on or before 11th of September 2026. Shameful.
Even though I have gone through it, after going through it, Lucy.
Authorized lordship.
Here in this case, my lord, Assam Board of Revenue has an order by single bench, but matter should be in the division bench. To that effect, my lord, I have filed an additional affidavit. Under Regulation 45, my lord, it is a division bench matter. By impugned order was passed by single bench. Similarly,
What order?
legally it is not sustainable. But that order at page 49, 50.
Review order is right.
Hello.
Argue on the main order.
Hello. This is the order, my lord, order 49.
File a suit.
Yes.
File a suit. Suit, you have no other way. Because you approach this court in the year 2020. Order was passed in 2013.
My lord, that was ex parte order, your lordship.
Understood?
That was ex parte order, and order itself is prima facie illegal, my lord, because it is the divisions bench matter. Your lordship would be pleased to see regulation.
No.
45.
Yes, it is true.
Regulation.
It's a division bench order.
My lord, it is division bench order, but order was passed by the single bench of the Assam Board of Revenue. It is not sustainable at all, my lord.
Why should we look into it in 2000?
My lord, we filed review petition, my lord. Review was
filed-
dismissed. Review was dismissed. Then I come before your lordship. Because, my lord, notice was not served to me. Delay is there, my lord, but I have not received any notice. So ex parte order. So ex parte order, thereafter, my lord, I filed review. Time is consumed there. And thereafter review order was passed. Against that, I have come before your lordship. That violation of national justice. Now your lordship would be pleased to see original order is not sustainable in law. Regulation 45. Time has passed, my lord, no problem. But this order is not sustainable. Your lordship would be
And what
pleased
is
to
the
see.
earlier order?
My lord, earlier order is this, my lord. It is against an appellate order. Because, my lord, mutation was granted in my favor. Thereafter, what happened, my lord? They approached the settlement officer. And settlement officer, mutation was wrongly done. And I approached the settlement officer. And settlement officer, my lord, corrected this. Against this, Board of Revenue was filed. Board of Revenue was filed. It is an appellate order. Against appellate order, my lord, division bench will take the matter as per Regulation 45. My lord. Assam Board of Revenue Regulation, my lord. Regulation 45. Your lordship may looked into my additional affidavit, my lord.
Was the
At
no,
page 60.
no, Mr.
My lord,
Was the order of the settlement officer
my lord.
the original order?
Original order by circle officer, my lord.
No. You
Yes.
did not, you could not have challenged it to the settlement officer. You could not have challenged
My lord.
it. If the circle officer's order is there, it would lie to the deputy commissioner.
My lord. It is the assistance that I'm giving, my lord. Your lordship, bear on minute. Your lordship will turn to page 25.
Page 37.
Page 24, my lord.
Page 37.
37.
This is an original order. This is the order which has been challenged before the Assam.
No, my lord, this is,
Yes, kindly
the-
see 11/6/2000 here, page,
Your lordship would be pleased
page
to see.
49.
Pleased to see the mutation order, my lord, page
No, no, no,
20
no, no, no.
24, 25.
This is an original order passed in Miss case number 82.
Mutation order is at page 24, my lord.
On that, kindly see the order at page 37. It says to be, it is an original order.
Not original order, my lord.
An original order. It cannot be, you cannot challenge an order unless it is an order of the settlement officer. Assistant settlement officer can be challenged before the settlement officer.
No, my lord, this is,
Kindly read page 37.
my lord, circle officer passed the order, original order.
It could not have been, because there is no challenge to that, no? Yeah, the Miss case has been started on the basis of a petition received from the petitioners, by which she has paid to correct the records from so-and-so, where so-and-so, the report of the Mondal so-and-so is given so-and-so. Now, here, you see the final order out here, Ella says, so after going through, I hereby restore the mutation of the petitioner in dark number and partner numbers as granted. The opposite party prayer for mutation over the land is cancelled as because they are treated as trespassers. It's an original order.
No, my lord,
It
actually,
is not an appellate order against an order because the settlement officer does not have the jurisdiction to sit over the circle officer's order.
no, my lord, as per law, circle officer's order is to be challenged with the deputy commissioner. But it is filed before the settlement officer.
No, that means the settlement officer's order is bad.
My lord, just 1 minute, my lord, your
Therefore,
lordship,
the jurisdiction.
lordship would be pleased to see page 24.
uh,
24 is the order passed by the circle officer, my lord.
That is not challenged by way of an appeal. Appeal is not that. It was an order passed in a miscase. Therefore, it was an original order. Original order is being challenged before the Board of Revenue. It is a single bench. When it is an appellate order challenged before the Board of Revenue, it's a division bench.
My lord, now your lordship will decide whether it is
Only
appellate
I
order.
can do one thing.
My lord,
Can only do one thing, that the jurisdiction was there, but however, if you are aggrieved that the order appears to be, my opinion, when I read that order, there he appears to be one mistake. That he went into the question of title.
my lord.
Therefore, can very well say that this order shall remain, however, shall be dependent upon any suit being filed by or the civil court's jurisdiction will be.
My lord.
Only thing you can get
On that line, my lord, petition will. be-
on that line. What do you say? Isn't it? Well, this is obviously the jurisdiction lies. Heard Mr. M.A. Sheikh, the learned counsel, appearing on behalf of the petitioner. The B.J. Talukdar, senior counsel assisted by so-and-so, appears on behalf of the respondent numbers 2, 3, 4. So-and-so appears for respondent number 1. You are? 5. Only 5. What about others? And
6 is the last respondent one. 5, 6 last. 5, 6 last one.
what about 7?
7 is struck down. Struck down.
Struck off.
Struck off. 6 is struck down, so 7 has come to 6.
Yes, on behalf of the respondent number 6. The present petition has been filed assailing the order dated 11/6/2013 passed by the learned Assam Board of Revenue in case number 151 RA bracket K oblique 2000 oblique 09, whereby the appeal was allowed, thereby setting aside the order dated 8/12/2008 passed in miscase number 82 of 2007-08 by the settlement officer. Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner, submitted that an order which has been passed, I have submitted that a review was sought for to the order dated 11/6/2013 passed by the learned Assam Board of Revenue. However, the said review application was rejected by an order dated 25/2/2020. And it is under such circumstances the petitioner has approached this court, now challenging the original order dated 11/6/2013, passed in case number 151 RA oblique bracket K oblique 09. The learned counsel appearing on behalf of the petitioner submitted that the said order so passed is without jurisdiction, inasmuch as the appeal ought to have been decided by the division bench of the learned Assam Board of Revenue. In addition to that, the learned counsel further submitted by the order dated 11/6/2013, the learned Assam Board of Revenue have also decided on the question of title over the land, which is solely to be decided by the civil court, and the revenue authorities have no jurisdiction. I've also heard Mr. B.J. Talukdar, the learned senior counsel, appearing on behalf of the respondent number so-and-so, who submitted that the settlement officer's order dated 8/12/2008 passed in Miss Case number 82 oblique of 2007-08 is an original order of the settlement officer. And under such circumstances, the appeal under section 147 Assam Land and Revenue Regulation 1886 is required to be adjudicated by the single bench. And that had been therefore rightly done. The learned senior counsel, appearing on behalf of the first said respondents, also submitted. On behalf of the respondents, also submitted that there is no perversity in the order dated 11/6/2013 passed in case number 151 RA bracket K oblique 09 for this court to exercise the certiorari jurisdiction. This court have also heard so-and-so appearing on behalf of the private respondents. Upon hearing the learned counsels appearing on behalf of the parties and perusal of the order of the order dated 8/12/2008 passed in Miss Case number 82 of 2007/8 by the settlement officer Gauhati, it is the opinion of this court that the said order is an original order of the settlement officer, inasmuch as the said order cannot be said to be an appellate order. Taking into account Regulation 45 of the Assam Board of Revenue Regulations 1963, it is the further opinion of this court that the appeal under section 147 of the Assam Land and Revenue Regulation 1886 is to be decided by the single bench of the learned Assam Board of Revenue, as the said order of the settlement officer was an original order. Accordingly, it is therefore the opinion of this court that the first ground of challenge to the order dated 11/6/2013 passed by the learned Assam Board of Revenue dated in case number so-and-so is misconceived. This court have further taken note of the order dated 11/6/2013, which is impugned in the instant proceedings. And from a perusal of the said order, it is seen that the learned Assam Board of Revenue have gone into the question of title of the petitioner qua the private have gone into the interstate title between the petitioner as well as the private respondents. It is the opinion of this court that the said expression of the said order having been passed by the learned Assam Board of Revenue, which is a revenue authority, has to be limited only to the question of revenue entries, and the same shall not therefore affect the inter se rights of the petitioner as qua the private respondents in respect to the title of the land. Accordingly, the instant writ petition stands disposed of with the following observations and directions. This court, for the reasons aforementioned, is therefore not inclined to interfere with the order dated 11/6/2013 passed in case number so and so. Number two, the said order dated 11/6/2013 passed in case number so and so shall not be deemed, shall not in any manner, shall not decide shall not be considered as a decision deciding the interstate title over the land between the petitioners and the private respondents. Number three, the parties, the petitioner as well as the private respondents, would be at liberty to approach the competent court of civil jurisdiction, if so advised, on the question of the title.
But only one thing, I'm fighting the litigation from 2013, my lord. Now what happened, my lord? I am to file the suit.
Are you in possession of the land?
No, my lord. What happened, my lord? From 13.
Are they claiming adverse possession?
26. No, my lord. They make claim. My humble submission before your lordship. 13, from 13 I am fighting. And fighting result is today come out. Now, my lord, my humble submission before you, as per Limitation Act.
What
if
is the
I claim
limitation?
12 years, my lord. If I claim on title, then suit is to be filed within 12 years. That problem may come, my lord. So on that certain observation, if your lordship please.
Just say, you are experts in civil law.
Not
I
expert,
need,
my lord. I
yeah,
know
you are
something.
expert. 12 years from when?
My lord.
12 years from when? Limitation is 12 years. From when? When their possession becomes adverse to you.
Yes.
Isn't it?
Yes.
Are they recognizing you as the owner?
No.
So there cannot be an adverse possession by them against you? Plea? Then is there a limitation? No.
My lord, they are in possession, my lord. Your lordship.
So they are
Just-
in possession, but are they
just-
claiming adverse against you?
No.
So if they are not claiming,
They are also said that.
no, Mr. Stake, it will come under Article 65. And Article 65 makes it very clear. The 12 years from the date they claim adverse against you, then the period of limitation will lie. So therefore I said, you are a civil lawyer, so you know it. Why should you ask me?
Well.
Anyways.
Oblige, your lordship.
This case petitioner has filed one verdict. I want to file one reply to that.
Lord, they have also, the private respondents, they have also filed one affidavit which I have received on Tuesday, my lord. We will also file, want to file a reply to that, my lord.
$4 lakhs is a share.
Yes, my lord, that is our contention, my lord. Because there is nothing in record to demonstrate that the 34 lakhs was paid to us either for surface compensation or for rehabilitation grant. Nothing has been, no communication, nothing. It was a pooling account, my lord, from where the amount was credited in our account, my lord.
What is the profit of the,
Sorry, my lord.
what is the profit of the tea company in that year?
Profit of the tea company, my lord, it's nothing there is in the record, my lord.
No, no, you say that it is out of the profits.
That is, my submission herein is
But
that, my lord, that can be,
Thus, you want to enter into.
no, my lord, I don't
No,
want, my
Yes,
lord,
yes, because of the fact that this amount, how many, have you ever received the profits like this?
no.
How do you say? That have they communicated to you?
But
That
how,
these are,
at the
no,
same
no,
moment, at the
no,
same moment,
Mr. Das, no.
I'm sorry, my lord.
My question is, have they ever communicated to you that you will be granted profits?
At the same time, they never communicated to me that this amount pertains to or
Did you
arises out of-
communicate to them that why did I receive this amount? Because you have to say,
Lord,
from the statement which is made at page 372, you say that you have received from them.
Lord,
Oh, there's no
Yes.
quarrel with that proposition.
no
Yes.
quarrel.
So did you ask them, why did I get that money?
Lord, I ask myself a question because similar amount was deposited to the other Milord Pattadar also
Yes.
from their 114 page number.
All other pattadas know that they have received it for the land compensation.
Lord, it's a presumption only. Milord.
No, they
There is
know.
nothing
Then
on record.
they have not all approached this court.
That's a
You
different
are the
fact, Lord.
only one who have approached this court. My question therefore is, did you ask them, why did I get that money? Because you categorically say, was paid by the respondent in lieu of the deed of agreement dated for profits. Now, does it the deed of agreement dated 5/2/2019?
It says about
states
profit
that-
sharing. Milord. It says about profit sharing.
It says about
Yes,
profit
Milord.
sharing. Let's see that again.
Yes, Milord. Lordship will find that deed of agreement. But in IA, Milord.
एक मिनट.
Page 41, it starts. This was an agreement in the year 2009 entered into by the HEF with the. Sorry. I'm sorry.
The agreement of 2009.
I'm sorry. I'm sorry. My apologies. Page 45, Milord. Para 3.
You are a what is
I'm a
the name-
pattadar.
what is
It's an
your name?
HUF. It's an HUF. I am a pattadar, Milord.
No, no. My question is, are you a party to this?
HUF is a party, Milord. This agreement was between the HUF and the three other persons, Bhanu Sharma, Kuldeep Sharma, and Natta Bhushan Sonowal. Bhanu and Kuldeep Sharma left later on, which is an admitted factual position. Natta Bhushan Sonowal remained, Milord. Then this agreement was for running the tea garden. Nothing more than that, Milord. It was only for the running tea garden. There was no conferment of possession or ownership to Natta Bhushan Sonowal by the HUF, Milord. And if you go by the Act of 1962, the oil is required to follow the procedure of Act of 1962, Milord, for acquiring the
You have given a
right
power
of way, Milord.
You have given a power of attorney.
Milord, there are two, I'll just explain. Milord. There are two significant incidents here. First is that in the year 2019, this agreement was executed with Natta Bhushan Sonowal, Milord, giving him authority to run the garden. Thereafter, whatever he has done, my lord, that is part of the record. In the year 2023, my lord, the Pattadars executed power of attorney with one Babul Sonwal for sale, excluding the portion which has been acquired by the oil mill. So there is no dispute with regard to that, my lord. And I'll just specify the amount, my lord. Babul Sonwal, my lord, the amount of rupees 94,70,670 was received by this respondent number 4 towards surface compensation, and rehabilitation grant amount total 7 crore 2,84,000 was received by respondent number 4. Thereafter, oil made a payment of rupees 3,50,000, 3 crore 50,61,000 to Babul Sonwal Miller, who was the power of attorney holder Miller. So these two significant events, Miller. So far as Babul Sonwal is concerned, it's an admitted factual position that we gave him power of attorney Miller. On the basis of that power of attorney Miller, he received an amount of rupees 3 crore 50,61,000, which is the 50% of the total amount. And rest 50%, the oil has assured that that rest 50% will be deposited after final agreement, Miller. So we are concerned with basically the first two amount, that is 94,70,670 and 7 crore 2,84,000, Miller. Our contention is that, Miller, the respondent number 1 and 2 followed a completely alien procedure in violation of Miller Act of 1962, Miller. Because since we have a clear set of law holding the field in the form of this act, Petroleum and Mineral Pipelines Acquisition of Right of Usury in Land Act 1962, this is only for the purpose of acquiring of right of way, Milord. When such a specific act is there in front of you, why you have tried to settle the land through a bipartite settlement with a manager? Because respondent number 4, in my humble submission, he is only a manager. An agreement was entered with him in the year 2019 only to run the garden. Neither any right of occupation nor any position was conferred upon them. If your lordship see the agreement, nothing was given to them, my lord. So our case is that the entire mischief was created by respondent number 1 and 2 by not following this act, my lord. Because had this act been followed, my lord will have a copy. Such beautiful procedure has been laid down here in the act, my lord, provisions. Everything has been, my lord, flouted in acquiring the land. Why? Why you have flouted? The act is there. You say urgency. What you are getting after flouting the procedure? From 2022.
You mean to say that they have not taken up this procedure?
No, nothing, nowhere. It's their admitted position that, I'm sorry.
It is a power of attorney entered by which you have given the power.
But one aspect I'll
Wait.
yes, I'm sorry.
You have given the entire thing over all your rights.
To Babul Sonwal.
Wait. You
Yeah.
have given it to him.
Yes.
By that. He has entered into an agreement with oil. For sale. Can you now question?
I'm not questioning that.
No, if you don't question this power of attorney, Mr. Das, if you don't question this power of attorney, can you question the present proceeding on the basis of not initiation of the Petroleum Act?
Lordship will kindly appreciate one aspect, my lord. I'll just a small submission, my lord. When this writ petition was filed, we don't have anything with us, my lord. If your lordship see the writ petition along with the annexure,
I will direct us inquiry to be made by the police on the basis of this statement which you are making. And if necessary, if it is a false statement, to initiate proceedings against you. This is apparently it appears to be a false statement on record. So initiate false proceedings.
lordship will kindly appreciate.
No, this is a very serious thing which you have done. No, Mr. Das. Merely because out here, first and foremost, that is why when the matter came up on that date, I put a specific question as to when you have issued the power of attorney. and thereupon an agreement of sale has been there, then you have a dispute qua that particular person. Why have you initiated the jurisdiction under this without cancelling the power of attorney?
My lord, cancel has
Then
been, my lord,
wait.
power of attorney has been revoked, my lord.
No, you cannot revoke it unilaterally, Mr. Counsel.
No, that's
First
it.
of all, you have to know the law. Don't make submissions just for the sake of it, Mr.
I'm
Das.
making submission
No,
because.
don't
there is-
make a.
I'm sorry, my lord.
When there is a power of attorney which is being executed out there, the power of attorney can only be revoked if it's a registered power of attorney, cannot be revoked unilaterally. That is the law. Now, thereupon, this it has been pointed out before this court that money was paid. And when the money was paid to this, now you say, and therefore I put a specific question whether money was received in your account, one, and secondly, did you take any steps for returning the amount? You say out here that this money was received out of your profits in respect to that agreement. Now, this agreement was not entered into with you. You were not a party to that agreement. That it was the HUF. Now, the HUF, you have never inquired, neither you have inquired with them from whom you have received the money, that this particular amount, is it a part of your records or not? They have categorically mentioned to that effect. So you have not returned it. So the filing of the instant writ petition is nothing but an abuse of the process of the court, for which we dismiss it with a cost of around 5 lakhs. And apart from that, initiation of proceedings.
My lord, in that,
Rest is for the division bench to look.
my lord, lordship,
No,
my lordship will kindly
I
appreciate, my lord.
dismiss, not only dismiss it with a cost of 5 lakhs.
My lord will kindly
and to
appreciate, my lord,
recover
lordship's
this 5
query.
lakhs, no, with
My
a
lord,
cost
may I
of
just,
5
may I just point out one aspect, my lord. Lordship's query was that whether this amount was deposited in petitioner number two's account or not. But we have very categorically stated
So
before.
that is why I'm asking the police to make an inquiry.
I'll just.
The police will make an inquiry as to whether this is so, whether this has been done in this manner, because this is what it is. I cannot make an inquiry, so let the police inquire about this thing.
Milord, may I just
You,
point out
I
one,
dismiss
Milord,
the cost.
Milord, may I just point out one thing, Milord? May I just point out one thing, Milord?
Mr.
Milord, may I just point out one thing?
No, remaining is for the division bench.
Milord, Lordship will appreciate, Milord.
No.
Milord, this amount was received
Out
by
of
me.
this
There is no
34
iota of
lakhs.
doubt, Milord. But only one submission, Milord.
You
Lordship
do
will-
one thing.
will
We'll
want-
entertain your petition. Deposit this amount in the registry.
May I just take the instruction, Milord? May I just take the
By
instruction?
tomorrow you deposit it.
May I just take the instruction?
Deposit the amount in the registry,
Milord, may I?
along with interest. Along with interest, the bank interest. Percent. Because you got the money in 2023, you have retained the money till 2026.
Milord, এক second.
Then
One
we will
second.
decide as to whether it is a question of profits or not. Then we'll look into it.
Milord,
One aspect, if I may just add to it, oil paid the money on 9/3/2023, and the money had entered into his account on 27/3.
possibility.
Proximity is also there.
No, Mr.
Possibility.
Sharma, that is not required. This court understands the falsity of the affidavit. Don't worry with that.
Just to add to that.
But what my
You
submission,
dismiss the
what my
court.
submission is that, Milord,
You
with all due
deposit-
respect.
No, you deposit this money along with interest at the rate of 9% before the registry by Monday. We will take it up.
Milord, I'll get the instruction, Milord.
No, you have to deposit,
No.
not the instructions. You have to deposit.
Just only to that extent, Milord. I'm just asked my colleague to
Yes.
get the instruction, Milord. In the meantime, Milord, what I am trying to emphasize before you,
I'm not
Lordship,
going to appreciate anything unless till you keep that money. I'm not going to hear that.
Milord, I understand your
Apparently
Lordship's query,
false,
Milord.
And I'll direct the.
Milord, I am with
to
your Lordship's,
explain
Milord. I understand your Lordship's query, Milord.
it. Apparently, Mr. Das,
It's, nobody will believe, Milord. I understand, Milord. Your Lordship is finding it difficult to believe and not believing. I also,
Yes.
nobody will believe,
not
Milord.
the question of finding it difficult. This
Because,
apparent-
but the fact is that, Milord,
the falsity of the thing will be looked into by way of.
Milord, the
as to
fact
whether
is
this
that
is a statement which is
at that amount would have been deposited in my account out of this rehabilitation or any other thing, there would have been a single letter given to me or the pattadar or a communication. Look,
because of the fact that Mr. Das, because of the fact that you have issued the power of attorney on 27/3/2023.
No, power of attorney was to Babul, not to, my lord.
He
This amount-
he had entered into the agreement with the oil on the basis of the power of attorney
I just,
for sale.
my lord, the power, lordship will kindly appreciate, this was paid to me by R4, not by Babul, my lord. I got this amount on, my lord, 27/3/2023. And it was given to me by R4, my lord, not by R3. Sorry, my lord, the Babul Sonwal, my lord. That's what, my lord, that's why the problem is arisen. They are saying that possibility, because I received on 27/7/2023, an agreement was of 9/3/2023 with Babul. Babul is a separate chapter altogether, my lord. That 3 crore 50 lakhs, that share will be getting from Babul, my lord, whatever he pays, proportionally to all the shareholders. But so far as this, my lord, 94 lakhs and 7 crore 2 lakhs is concerned, my lord, we haven't received anything out of this.
Obviously, they have not paid. They have not paid it. They have categorically said that we are not going to pay till the agreement is
No,
sale deed is executed.
my lord, may I just, one second. May I just clarify, my lord? Three amounts, my lord. First, 94 lakhs, then 7 crore 2 lakhs. That has been already paid to respondent number 4. Then another amount was 3 crore 50 lakhs. That is paid to Babul after the power of attorney, after entering into an agreement to sell. So these two amounts are different, my lord. That is what I am trying to convey. This amount, 35 lakhs, R4 claims that this was out of this 94 lakhs and 7 crore 2 lakhs. 3 crore 50 lakhs is still there with Babul, my lord. Lordship will kindly appreciate. The share of that money we will get. Angshu Bona, kindly have a seat. The share of that money we will get. That is not in dispute, my lord. There is some dispute with Babul and with Babul regarding, my lord, power of attorney. That is a separate chapter. Here we are only, lordship seen the pleadings also in the red petition. We are only concerned with this 94 lakhs and 7 crore 2 lakhs. How you have settled this with respondent number 4, who is a manager in violation of the act. That is the simple case before your lordships. And that's why, had there been, if, fine, my lord, he is willing to pay us. All through years, he never paid any amount to us out of profit. He got this 7 crore and 94 lakhs, and he wanted to decide that we'll pay him. Will you not come in, issue a simple letter, not to me, at least to the Karta of the HUF, all other communications regarding.
None of the Karta of the HUF is before this court.
That is a proposition. He is saying that possibility of the date, the amount released, then agreement entered into. So proximity is there between the date. I am also making a proximate submission. All other communications, when you ask, when you take permission to get the money from oil, you write a letter to the Karta of the HCF or the authorized signatory. Look here, I am getting surface compensation from oil of 94 lakhs. Can I get it in my account? All communications made, my lord. But when you make this communication, deposit this amount, you neither write a communication to the HUF nor to the Pattara, no one, my lord.
Then the money first.
My lord, we'll deposit. My instruction is that
Monday
some
with 9% interest.
immediately we'll deposit.
With
My
9%.
instruction.
You got the money on so and so, no?
My lord, interest may not be, my lord.
9% interest.
May not be, my
Return
lord.
The interest.
They have also retained my
No,
money.
no, we'll give you the interest back.
Fine,
tomorrow.
fine. But one more prayer, my lord. Small prayer, my lord. They have filed an affidavit, my lord. Sometime lordship will permit me to counter that affidavit, my lord.
I am giving you much time, but first deposit.
Deposit, my lord.
Yes, I'm having it on Tuesday matter. Again, by Monday you deposit along with 9% interest from the date you have received it. You received it on 27/3/2023.
Correct, my lord.
So you deposit that amount, then only we can consider.
Can it be on 5th? The listing of the matter, my lord. Money will deposit by Monday, my lord. Listing of the matter on 5th.
This court by an order dated 20 by the orders dated 23/6/2026 and 21/7/2026 categorically sought for made inquiries with the petitioner as to whether the amount of rupees 34,16,688 was deposited in her account on 27/3/2023. And as to whether the petitioner thereupon took any steps to return the amount back to the respondent number 4. An affidavit has been filed by the petitioner. The affidavit is filed, but an affidavit in compliance have been filed by the petitioner on 31/7/2026, wherein the petitioner categorically admits the receipt of the amount of rupees 34,16,688 on 27/3/2023 in her account. However, it is the case of the petitioner that the amount of rupees 34,16,688 was paid by the respondent number 4 to the petitioner in lieu of the deed of agreement dated 5/2/2019, that is for the profits made over the years by conducting the affairs of the tea business of Patangpani Tea Estate. This court, prima facie, is not satisfied with the said reply, more particularly when the petitioner since 2019 have not received a single penny from the respondent number 4. Apart from that, the petitioner have not explained, have not also mentioned that any inquiry was made with the respondent number 4 pertaining to the amount of rupees 34,16,688, which the petitioner claims to be the profit over the years. Nothing has been also placed on record to show that the amount of rupees that the tea estate business had accumulated profits to the tune of rupees 34,6 have accumulated profits to the extent that one of the 38 members of the HUF, 38, would be entitled to profits to the tune of rupees 34,16,688. This court, therefore, being not prima facie satisfied, is of the opinion that if the petitioner wants to proceed with the adjudication of the instant writ petition, the petitioner cannot be permitted on one hand to retain the amount of rupees 34,16,688 and the which the petitioner, as well as the benefits thereof, which the petitioner has been enjoying since 27/3/2023. Mr. H.K. Das, the learned senior counsel, appearing on behalf of the petitioner upon instruction, submits that the petitioner is willing to deposit the said amount along with interest. Accordingly, taking into account the above, list this matter on 5/8/2000.
Look, may I just
5/8/2026.
some time to file the reply? I'll deposit.
I'm
for depositing.
replying is okay.
Fine, my lord. Fine, fine.
5/8/2026. In the meantime, the petitioner should deposit before the Registrar General of this court the amount of rupees 34,16,688 along with interest at the rate of 9% per annum with effect from 27/3/2023 till 3/8/2026.
My lord.
A report,
There was an interim order passed in the writ petition earlier, my lord.
there's no interim order. I've already vacated those interim.
Okay, fine. Lord. Fine. Highly obliged, much obliged. My lord, fifth only for this deposit only, my lord. Yes. Deeply obliged.
The petitioner was issued with a notice by the GMC to vacate a cowshed by law. And as this notice was served without hearing the petitioner, so the petitioner approached this honorable court. Your lordship kindly turns to page 39, my lord. Page 39, operative para 3, my lord. The
You have been
petitioner.
dispossessed.
Yes, now thereafter relevant portion is at page 41, my lord. From top, my lord. Page 41. Since no notice to show cause mentioning the ground was issued prior to issuance of notice so directing removal of the cowshed maintained in the premises of the petitioner shall submit a reply to the said notice dated so and so within 2 weeks, showing reason as to why the petitioner may be allowed to continue with the cowshed in the premises by treating the notice dated so and so as.
Who has dispossessed you?
Now, the
Who has dispossessed you?
TMC. Now, initially,
I am appearing for the private respondent, respondent number 6.
DMC?
We have not lost. Because the police authority, lordship,
The mic?
it is the, so although we are intending to, demolish the cowshed there, lordship. Ultimately, it was the police authority and the private respondents, they both went there before we reached the spot, lordship, and it was demolished. That is the fact we have explained in our affidavit, lordship.
Page 103, my lord. It is the GMC initiate 103, my lord. They have filed 3 affidavits, my lord. They have said that it was on the basis of the GMC authorities that they have requisitioned for police force, my lord.
Yes, it was there. My name is Sonu Bora. I am.
Page 104, this is the affidavit by the policeman.
So and so I was serving in the enforcement. Demolition of contemporary government at any. Who is he? How did you get this document?
But they have filed the affidavit, my lord. The respondent number, this affidavit has been filed, my lord, by respondent number 4 and 5, my lord. Police authorities. Initially, my lord, the GMC have filed an affidavit. They said that, my lord, it was done by the police authorities. They are not aware about it. Subsequently, my lord, the police came and filed an affidavit saying that on the basis of the requisition of the GMC commissioner, they have deployed the police personnel. And this inquiry was also, this report was submitted, my lord, page 98, my lord. The OC Bhoralimuk, page 98.
Who has submitted?
Yes, my lord, the police, my lord. OC Bhoralimuk, my lord. Page 99, chapter 8 is stated that based on the request of the page 99 onwards.
Now, what is the, why are you saying, what is the problem with the demolition?
No, my lord, demolition was that as per the Honorable High Court's disorder, the time was given up to 9th of May. Because if your lordship.
When was it demolished?
On third, my lord, 29th. On 29th of.
How do you say it, 9th of May?
Because page 41, your lordship will kindly come, this order. It says that on receipt of such show cause, first, second, third, fourth.
You submitted your reply when?
I could not submit, my lord. Before that, they have demolished.
Submit a reply to the said notice dated within 2 weeks. going reason why the petitioner may be allowed to continue with the premises by treating notice to show cause. If or where the competent authority in the GMC shall either the same. Okay, so you are given 2 weeks.
2 weeks from 25/4, my lord. On 29th, my lord, they came and demolished, my lord. Now, the private respondent also filed an affidavit saying that the land belonged to the private respondent. Once they have cleared this land, he has taken possession of that land and he has sold it to someone else. So meaning thereby, my lord, how the private respondent is.
Were you the owner of the land?
No, my lord, I was in possession of that land.
I was in possession of the land.
Of that land.
And you
Since
have been
1970
dispossessed by the private respondent.
But by the police, my lord. In collusion, my submission is, my lord, this private respondent collusion with state authorities, my lord, they have dispossessed the petitioner. Before, my lord, because this honorable court's order was that till 9/5, my lord, I was given 2 weeks time. So before expiry of 9/5, my lord, they have demolished us. And they have taken possession.
By
of
the
that-
GMC.
The GMC. GMC now, had it been, my lord, only GMC, they have demolished the cow shed. Now, the respondent number 6 have filed an affidavit that once this plot was cleared, he took over the possession and he had sold it off.
That's a different thing. He
Yes,
has sold it.
so-
So that whom it has been sold, he is not a party.
No, my lord, if he is, because if it was not done as his instance, my lord, how he could know that the moment it was cleared, he went and take possession, my lord, of that plot of land?
Understood.
Yeah,
So therefore, whose land it was?
It was my land.
It was private respondent's land.
How was the writ petition filed?
It petition filed because, my lord, the petitioner was in possession of that land. Now, the GMC has given a notice that she was operating a cow shed from that land. You vacate it. Now, as no prior notice was issued, so we approached the court. Court had said that notice of 28(3) that will be treated as show cause. File a reply. It's 39, my lord.
What cow shed is this?
At page 83, lord. Photographs and.
(28)(3), 2022. The notice was issued to you.
Yes, madam. So against that, we approached this court. This court on 25/4/22.
25?
25/4/22, page 40. Page 40, left-hand side, madam, top. 40 page.
25/4/2000. That is after 20 days.
Yes, madam.
After 20 days, this has happened.
Yes, now the court said that as no prior notice was issued, we were not heard, so this notice would be treated as show cause and we were given 2 weeks time to file a reply. Now from 25/4/22, my lord, the 2 week time expires on 9/5, my lord. And till then, my lord, last person, the GMC authorities, no caution acts of in terms of notice dated so and so as indicated here shall be taken against the petitioner. So we were protected, my lord, till 9/5. Now, before expiry of that 9/5, on 29th, my lord, they came and they demolished that premises and evicted us therefrom, and ultimately, immediately private respondent took over the possession of that land. Now, first of all, my lord, while evicting, my lord, due process of law was not followed. Secondly, my lord, there was an order
The
protecting.
due process where respondent 6 was involved.
Yes, ma'am.
Then is the case of civil dispute.
But that is why, but here, my lord, it is not the respondent number 6. Had it been a case that respondent number 6
GMC will only demolish.
yes,
But GMC will not
but
evict you.
yes, GMC will only
If the
demolish.
land belongs to the respondent number 6.
Yes,
So the GMC is not demolishing on the account of illegal construction. GMC had issued the notice on the ground of
Public complaint.
dog dung, cow dung and urine which falls on the drain.
yes,
has polluted the environment by pungent smell.
Hmm.
As a result of which nearby residents are apprehending ailments. Skin is also blocked from cow dung.
No, the residents of the vicinity have also submitted before the GMC at page 34 that not to remove that cow shed because the residents are being benefited from that cow shed. They are getting milk and all those things. They are
No, but-
performing business. So if it is that GMC on the basis of a complaint, so our contention is that if GMC on the basis of complaint of some private individuals.
Now,
have
my
issued-
question is,
Yes, ma'am.
there may be, but this court direct them to restore your possession.
Yes, ma'am.
The land and the building or land or
Mhm.
anything is under the occupation of some third party whom he sold it.
No, no. So
That is the,
they-
that
they-
is the problem which this court is facing.
So,
If it was only limited to the GMC or the state,
yes,
this
ma'am.
court have very well directed. First, the problem lies that there is a land. The land admittedly belongs to him.
Private respondent.
You were in possession of that. Of right or whatever
Oh,
may be,
yes,
you
yes.
were in possession.
Yes, ma'am.
The GMC as well as the other authorities
Yes, ma'am.
have played some work
Yes.
in collusion with the respondent number 6, thereby to demolish your shed. Now, can this court pass an order directing them to hand over when didn't that amount to an excess of jurisdiction
No, no,
under
no.
Article 2 to 6 of the Constitution, more particularly
Yes.
when the land is a private land
Land.
and the land belongs now to somebody else.
So therefore, my lord, we are
The
not
thing
on
is,
that
the
we
civil
have
court-
restored the possession.
Civil court ask for compensation. That is the only way out.
No,
Can't help it.
we say
The
that
question
let
of
it, let my lord a judicial.
Because I am not exercising a contempt jurisdiction here.
Yes, my lord.
So therefore, if there is a violation, it is a question of contempt. So don't you think that it is only the civil court who can decide this?
No, because my lord, under this, as the GMC was also a party to the earlier litigation.
There
Yes.
is no
ma'am.
quarrel with that.
So therefore, my
Now,
lord,
therefore, that there are questions out there, yes, there is a violation. But I'm not in contempt jurisdiction.
yes, my lord.
So if it is a violation of that, it is okay. If there is a violation for that particular person who were responsible, the court will take action for violating that order.
Yes.
Whatever it may be. But as of now, this court pass a direction directing them to hand over the possession which belongs to somebody else now to you.
Lord, apart from the prayer for handing over possession, we have other prayer also that let there be an inquiry and compensation be paid to this poor fellow, my lord, because she's an illiterate and she was operating.
Compensation you are asking for?
I am not, my lord, let this court decide, my lord.
Who will pay you the compensation?
My lord, because in violation of the court's
If
order.
there is a violation of the court's order, it's a
No, my lord, lordship will.
circumstances. How can there be a direction of compensation?
Because in
Letter of
spite of,
evidence also.
in spite of,
Letter of evidence also violation, madam.
No, the question of compensation, this court cannot direct here. There are many things, whether Mr. Nayak, who was appearing out there, informed the GMC commissioner or not. Did you inform that order? Did you submit that
yes,
order
my
to
lord,
the
we have said
GMC?
that there is an high court. On the date when they came, we showed them, see, there is an high court order, my lord. So they.
My question is, did you inform the commissioner?
No, we were under the.
You were also under an apprehension that the council who was
Will
defending
inform.
the GMC would have informed.
Informed, yes, my lord, yes.
So if Mr. Nayak has not informed,
Informed.
can the GMC commissioner be settled with the compensation?
So,
What the
lordship,
council was defending. There are many aspects which
Aspect.
cannot be adjudicated here.
let me take instructions, my lord.
The hearing so much. Only
No,
thing
we
is
are enlightened, my lord.
instruction.
We are enlightened to
There is
appear.
no- One thing you have to is whether you like to withdraw or will I dismiss. Either of. Liberty, dismissal with liberty to approach the ear.
Will approach the civil court, my lord.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the respondent number,
1, 2, and 3, Lord.
respondent numbers 1, 2, and 3. Mr. Endas appears for the respondent number 4 and 5. Mr. So-and-so appears for the respondent number 6. The present petition has been filed by the petitioner challenging the actions on the part of the respondent authorities in evicting the petitioner in concert and in collusion with the respondent number 6, despite there being an order dated 25/4/2022 passed in WPC number 2677/2022. The respondent number 6, you have filed affidavit?
Yes, Your Lordship, I have filed.
Filed an affidavit. It is an admitted fact that the land from where the petitioner have been evicted belong to the respondent number 6. And it is the stand of the respondent number 6 in the affidavit that pursuant to the eviction of the petitioner, the respondent number 6 took over possession and sold it to a third party. In the backdrop of the above, if this court duly takes note of the reliefs which have been sought for, it is the opinion of this court that as the land in question admittedly belonged to the respondent number 6, and the respondent number 6 has thereupon sold the said land and handed over the possession to another third party. The question of issuance of a direction in exercise of jurisdiction under Article 2 to 6 of the Constitution to restore the possession of the land to the petitioner cannot be passed. This court also finds it relevant to take note of that the petitioner have also sought for compensation for evicting the petitioner illegally from her land, from evicting the petitioner without following the due process. For the purpose of adjudicating as to how much compensation, or for that matter, whether there is any compensation to be payable by any person, it is the opinion of this court that questions of facts have to be looked into, question has to be adjudicated. It is the opinion of this court that the competent court of civil jurisdiction would be the appropriate forum wherein the petitioner can approach. Under such circumstances, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Be that as it may, it is observed that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner in respect to all the claims which have been raised in the instant writ petition to be raised before a competent court of civil jurisdiction.
Well, it's small, they have said that the private respondent have sold it to some third person, but they have not disclosed it. Let him disclose to whom because for service of notice, my lord.
Lordship, even I also don't know. I have to take the instruction from my client, Lordship. The name of the present owner of the said property.
Take it,
Lordship, I'm saying that I have to take the instruction. I don't know the name of the owner.
take it and by 3 o'clock, give it to us. We'll
Lordship,
keep
I will do it.
Else, what will hold it that there is no sale. And if there is no sale, then it will go against you.
They have sealed it.
Get the instruction by 3.
Lordship.
Sell it now, what will it? Sell.
What is this, Mr. Sharma?
My lord, it's eviction, my lord.
Affidavit file.
Yes, my lord. Railway has filed an affidavit, my lord.
Lordship,
What is your matter?
Page 35 is the, my lord, page 35, my lord.
35.
My lord.
For the direction, you are hereby directed to vacate the aforesaid land, plot of land, and remove your structures and establishment at Bongaigaon so and so, encroaching government land measuring 1 biga, 1 kata 15 lectures.
My lord.
In the opinion, the affidavits on behalf of the Imam, General Railway of the who are required. Who has filed the affidavit?
Railway, my lord.
What do they say?
My lord, they said that, my lord, it's a railway land, my lord.
What do you say?
Lordship, kindly.
And if it is a railway land, what business does it have? You are appearing for railway. Huh?
For respondent number 5 to 8, Lordship, for railway Lordship, kindly. Take our.
You say it to be railway land. What is your instruction? We asked the affidavit of the circle of the Bongaigaon.
Yes, Lordship. I am unable to file it because of while preparing the affidavit, it come to my mind that where this notice is issued to the railway, when it belongs to the railway. And I have gone through that notice whereby it is stated that it's a government land. In the notice itself, it is stated as a government land. Accordingly, I had inquired with the circle officer, and circle officer has given me these instructions. That is why I am unable to file the affidavit immediately. I am placing it that in the that amongst that railway land, there are government land also, Lordship. This is regarding the government land. But this notice, Lordship, if we go by the notice, this is not properly. There is no schedule mentioned in the notice as well as the so cause is not.
But the disputed land is recorded as railway land in the draft sita.
In draft sita, in handwritten, I have been told that in ink, Lordship, it is written as railway land. But in the original, in computerized sheet, it is written as government land.
So-
That is the dispute, Lord.
So when you are not very clear as to whether it is government land or real land,
That is why, Lordship, I have.
so we have to set aside
Yes,
this notice.
yes, Lordship.
And
I have.
thereby then whenever you find out, then you take action.
Lordship.
But on the basis of both of your different disputes,
Yes,
you
Lordship.
cannot
Lordship.
allow your petition in that regard. Heard Mr. R. Sharma, the learning counsel. H. Sharma appears on behalf of the
2, 3, and 4.
respondent number 2, 3, and 4. And Ms. So-and-so appears on behalf of the respondent numbers 5 to 8. Present petition had been filed by the petitioner being aggrieved by the notice which was issued by the Circle Officer, Bongaigaon Revenue Circle, dated 14/6/2024, whereby the petitioners were directed to vacate the plot of land and remove the structures and establishment with immediate effect. It was also mentioned in the said notice dated 14/6/2024 that if there is a failure on the part of the petitioners to vacate the land, comma, necessary steps would be taken for eviction under the provisions of the settlement rules under the provisions of the Assam Land and Revenue Regulation 1886 within 15 days from the date of issuance of the said notice. It is the specific claim of the petitioners herein that the land in question is a railway land, and as such, the respondent number 2, 3, and 4 being the 2, 3, and 4 have no authority or jurisdiction to take any steps for eviction of the petitioners from the railway land. So, when the matter was listed before this court on 17/6/2026, this court sought for affidavit, the stand of the Circle Officer, Bongaigaon Revenue Circle, as well as the Divisional Railway Manager, Rongya Division, NF Railway, by filing affidavits. An affidavit has been filed by the respondent numbers 5 to 8, wherein it is categorically mentioned that the land in question is a railway land. Wherein it is categorically mentioned at paragraph number 8, 10, that the land is a railway land. And in that regard, the kita in respect to the land have been enclosed as Annexure 1 to the said affidavit. The Circle Officer, Bongaigaon Revenue Circle, however, have not filed the affidavit. Mr. H. Sharma, the learned additional senior government advocate, have placed before this court an instruction issued by the Circle Officer Bongaigaon Revenue Circle to the Additional District Commissioner Revenue Bongaigaon, which is dated 28/7/2026, which is kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that as per the field verification report submitted, the land in question, bearing dark number 119 of Revenue Village Bongaigaon Town, Part 1, is recorded in the land record as government land, and the class of land in is Sreni 9. But the disputed land is recorded as railway land in the draft Shita. From the above, it is therefore very clear that the revenue authorities of the state of Assam, more particularly the Circle Officer Bongaigaon Revenue Circle, without first having assured itself that the land in question is a government land, have initiated proceedings under Rule 18 of the Settlement Rules, framed under the Assam Land and Revenue Regulation 1886. It is the opinion of this court that Rule 18 of the Settlement Rules can only be exercised when the land in question falls within the categories of land specifically mentioned in Rule 18.2 of the Settlement Rules. In the instant case, as the revenue authorities and more particularly the Circle Officer Bongaigaon Revenue Circle is not sure as to whether the land in question is a government land or a railway land, the exercise of jurisdiction by the Circle Officer Bongaigaon Revenue Circle issued a notice dated 14/6/2024 stands vitiated. Accordingly, this court therefore sets aside the notice dated impugned notice dated 14/6/2024. Before parting with the record, this court, however, finds it relevant to observe that in the circumstance, after proper verification, if it is found that the land in question is a government land, the respondent authorities in the revenue department, the respondent revenue authorities can only take action by issuing proper notice in terms with the judgment of this court, of the learned division bench of this court in Muhammad Salahuddin. Oh, this one. Happening.
Bring into record, my lord, the minutes of the meeting dated 29/6, where it has been decided that, my lord, the lease will now be cancelled in respect of the petitioner. And they will go for some, my lord, renovation of the entire park, to upgrading it to a, my lord, model eco park.
Yes.
It's very interesting. Have you seen the file?
Yes, my lord, I have seen.
Is it, who has issued this document?
By the Chief Secretary, my lord.
It now.
The tourism department was directed to by Assam Tourism Development Corporation Limited as a nodal agency for the preparing and implementation of the proposed eco park development project. Department was further instructed to initiate a proposal for advising the fisheries
Further
department.
instructed to initiate a proposal for advising the.
He has presided over the meeting, my lord. So he has signed it. But it will be developed.
Okay, now your decision is now to give him back the security deposit and all these things.
As per the, my lord, agreement, my lord, whatever is due is entitled.
I've received a copy today itself, my lord, sometime back. I'll take the instruction, my lord. If required, I'll file a reply.
Reply, you have to challenge this if you are. Right now, of this decision.
Yes, my lord.
Court cannot pass the which have been sought for unless you get this decision set aside.
Yes.
Because therefore I see it's 331, if you see, or that you are not a party to that.
Yes, my lord. I was not called, my lord. Till now, I have not issued the notice also, my lord.
So they will now initiate process.
Yes, ma'am. In terms of the
issuance of notice. An additional affidavit has been filed by the Chief Secretary to the government of Assam, placing on record the decision which was taken in the minutes of the meeting held on 29/6/2026. Taking into account the said decision, taking into account the above, the Mr. Asrikar, the learned counsel appearing on behalf of the petitioner, submits that he has received a copy of the additional affidavit today and he would like to obtain instructions. Matter when? 26th August.
Most obliged.
Pick it up after some time. Only the name has to be given.
Yes.
Huh?
My pleasure, Lordship. Lordship, we have filed a rejoinder.
Hmm?
We have filed a rejoinder, Your Lordship.
I'll
My lord, will see your affidavit, my lord. We have disputed the claim made by the petitioner. Our affidavit speaks that, my lord, even, my lord, there is no record to show that the work was actually allotted and there was any work executed by the petitioner. Aspect of the claim made. It starts at, my lord, page 90, 89. Lordship will see, my lord, para 5 and 6. As well as 17.
your reply, Mr. Counsel.
If Lordship permits, Lordship may hear us on the next date.
Huh?
Lordship may hear us on the next date, Lordship. Lordship, we filed the reply yesterday. Lordship, I was of the assumption that it won't get tagged, Lordship. Lordship, I was of the assumption that it won't get tagged that soon, Lordship.
Who?
But prepared, Your Lordship. If Lordship permits.
They've been go to the civil court now. No other way. In view of the categorically saying to be fraud, and they are not claiming that the amount is being liable to be paid. Without an admission, how can this court exercise 226?
Give us a chance to hear, Lordship. Lordship, my senior will be there in the next day.
Senior?
Lordship, A. Chetia.
Available. When will he be available?
Lordship, any date Lordship gives him.
Hello? Monday?
Yes, sir, Lordship.
The matter on behalf of the petitioner submits that his senior is not available, taking it, publish the matter on Monday. Date to be.
Petitioner is a life convict, Lordship. He is under imprisonment since last 25 years. He made an application for remission provision.
What happened on 22?
Lordship, on 28, Lordship, it was placed, but we have not yet received that decision, Lordship.
Senior government advocate submits decision of the review board meeting, which was to be held on 2/7.
It was held on 28/7, Lordship.
held on 22/7/2026, but was subsequently held on 28/7/2000, have not been intimated to the petitioner, have not been intimated, Taking into account the above, as there was a review meeting held on 28/7/2026, list this matter on 7th of August 2026, on which date the petition of the review board, a review meeting, petitions taken in the review meeting for the petitioner be placed before us.
Fixed it on 7th of August.
Look, you will see the affidavit, my lord. We have filed the affidavit, my lord. The admissible amount will be 6,38,148.
Police or what?
Yes, my lord, Home Department, regarding hiring of vehicles.
Police or husband?
There are, my lord, five.
4 and 5 court. DP will pay.
Or so you say that, my lord, Home Department will pay.
This is
Proposal will have to come from, my lord, Karbi Anglong, then it will be moved.
It will be paid by whom?
Home, my lord.
DGP now. It is that, who will be making the payment? The Commissioner and Secretary, whom?
Or so will say DGP, my lord. Payment will be made at a DGP level. But bills will have to come from the district. And district authority is not a party here in actually, my lord, the actual, my lord, amount has been, my lord, ascertained by the senior of my lord Karbi Anglong. On his
Okay,
instruction.
now the whatever may be,
Ultimately, respondent will pay, my lord. This amount has been
the
admitted.
payment will be made by the DGP.
DGP, Lord, so will.
Please. Yes, Mr. Hussain, what is your case?
This is regarding, my lord, settlement of land, my lord.
We have filed our affidavit, my lord.
Do you say?
Admit the facts, my lord. Yesterday filed by the circle officer. my
They say.
My lord, the land was allotted in their favor, my lord. They are in the position of that. If approved, that can be done, my lord. If approved, my lord, from the concerned committee, my lord, it can be. So lordship, come to PS 43.
So the settlement order has not been passed. Why?
Re-verification also has been done. It was found they are in a position of the allotted land. Only 2 bigger, one said 10 desa, one said 9 desa.
Kota
Oh,
10
2
less.
kota, sorry, 2
Two
kota.
kota 10 less, sir.
2 kota 10 desa. One report says 2 kota 10 desa, one says 2 kota 9 desa. Page 46.
From a perusal of the
Circle officer, my lord.
circle of
Yesterday.
the,
Bileshwara Revenue Circle. my lord.
which one?
Respond number 4, Bileshwara.
Ilasipara Revenue Circle. Any
Paragraph 9.
petitioner. That the petitioner, that there is an approval from the SDLAC on 6/8/2024.
The affidavit is lying defect in the, it's lying defect, my lord. Affidavit which I filed yesterday.
Will
Just
not
now.
file a
Yeah, I filed, it's lying defect, my. Some.
The circle officer, the revenue. Commissioner Dhubri,
What is the commissioner, Vilasipar?
along with the respondent number 4 and 5, have not filed the affidavit, in spite of the fact that the
No, my lord, it has been filed,
notice
my.
have been issued as far back as on 8/9/2025.
No, my lord, it has been filed, my lord. It has got some defect. It's lying in the defect, my lord. Yesterday it has been filed, my lord.
And as the learned counsel appearing on behalf of the respondent number 4 and 5 submits an affidavit has been filed by the circle officer.
Who
Bilasipara
district
Revenue
commissioner?
Circle.
Who district commissioner Bilasipara?
However, the said affidavit is not on record. This matter again on 12th of August 2000. A registry shall bring on record the said affidavit. The defects are being cleared by Mr. N. Das, the
Yes, ma'am.
learned counsel, government.
May I please your lordship? Lordship, this property has been sold to one Mr. Kailash Lohia. I will furnish the details and address to the this honorable court.
Party namely.
So I will provide him the details. That I don't know, lordship.
Provided.
I'm deeply aware.
An order on 12/3/26. The director of archaeology was not a party in this case. That's why he was implemented as a party. So I filed the implead petition.
What has happened now? We appear for the director of this has not been issued.
Official notice has not been issued, but we have
Okay, it
served
has
a
been
copy.
issued. Who appears?
My lord, the notice was not issued.
As Mr. P. Talukdar, the learned senior is on behalf of the newly implemented issuance of formal notice is dispensed with. I've got the extra copy.
I have one copy, my lord. One copy, not extra copy.
Add one more copy. The B.J. Talukdar, the learned senior counsel for the state, submitted that a copy may be provided so that he can then number 5 being on record it stand. Please, Mr. H. Rahman, the learned counsels for the petitioner submits that the needful would be done in 2 days. This matter on the being on record, affidavits on of witness. What is this matter?
To file additional affidavit, bringing on the documents which proves the.
How they are connected with that, no? Isn't that? The petitioner is not represented. For the ends of justice, the matter stands adjourned to be listed again. 11th of September 2026. We'll have it on 10th of September 2026. Observe that in the circumstance the petitioner is not represented. Date. Court would proposal on the basis of would be constrained to pass appropriate directions. Yes, what is this?
Matter relates to lordship land demarcation lordship. Can I have filed his representation before the authority?
What is your stand? respondents.
30.
I am here. The demarcation has already been completed, Lordship. Regarding that trace map, Lordship, as there is the regarding that plot of land, there was a dispute, civil dispute. And the petitioner was not found to be the absolute owner of the PP Patra number 12, Doug number 39, 40, 192 and 255. Accordingly, the trace map was not issued to him. Trace map was not issued to him as because the matter is sub judice before the civil court, Lordship. That is the instruction I have received. If your Lordship directs, Lordship, in that case, we can provide it.
Trace map and as well as the proceedings of.
By that way, Lordship, it can be disposed of, and the demarcation has already been completed. Only that trace map.
Copy.
Lordship.
Why did we, when the certified copy, within 10 days of the certified copy?
Lordship.
Sharma, the learned additional senior. On behalf of the respondent number 2, 3 and 4.
Lordship.
The petitioner has approached this court being aggrieved by the inaction on the part of the respondent authorities to carry out the demarcation of the land, Patra number 309 of Dag number 652 and Patra number 310, Dag number 52. What is the? The petitioner has approached this court seeking direction upon the respondent authorities to issue the trace map of Dag number 39, 192, 255 of Patra number 12 of Rampur Kismat under Hojai Revenue Circle, semicolon, for a direction upon the respondents to demarcate the land Patra, land 652 of Patra number 309 and Patra number 310. It's difficult to understand what prayer you have made. Wait, I have also here to sort of direction. I've also sought for demarcation.
Demarcation was also done pursuant to Lordship.
Of the entire land of Patra number 12 of Rampur Kismat Dag number 55. H. Sharma, the learned additional senior government advocate, submits that the demarcation was carried out on
31/12/2025.
31/12/2025. However, as the petitioner was not found to be
Is not the absolute owner of PP number 12, tag number 39, 40, 192, 255.
not found to be the absolute owner of Patra number 12 of
Yes, Lord.
Tag number 55.
The scheduled land is sub judice before the trial court.
As well as the scheduled land being sub judice before the trial court. The trace map have not been issued to this court, to the petitioner. This court has given an anxious consideration to the respective submissions. And it is the opinion of this court that the trace map being it is the opinion of this court that as the respondents herein, the respondent revenue authorities duly claimed that there was a demarcation carried out on so and so. The petitioner, and that were at the instance of the petitioner's application, and that were the instance of the petitioner who has submitted the application. The petitioner is entitled to a copy of the minutes of the demarcation proceedings. In addition to that, the trace map being a public document, the petitioner is also entitled to a copy thereof. Accordingly, this court therefore disposes of the present writ petition, thereby directing whom?
Circle officer.
The circle officer, which place? The circle officer,
Revenue, sir.
Hosai Revenue Circle, to provide the petitioner the minutes of the demarcation proceedings as well as minutes of the order of the demarcation proceedings which was held on so and so in connection with Patta number 12 of Dag number 39 40 192 255 of Rampur Kismat under Hojai Revenue Circle, and also provide the trace map upon submission within 10 days from the date of submission of the certified copy of the present order. With the above, the writ petition stands disproved.
May I please, your worship? In this writ petition, petitioner challenge the order at page 14, Annex 2, on the ground that the petitioner number 2 was compelled to surrender his license, PDS license, at the instance of the official respondent, to the effect that he is, my lord, elected as the Gau Panchayat member, and under the Panchayat Act, he is not eligible to continue as a PDS holder, my lord. In affidavit to response, they have filed, my lordship. Kindly see page 35 of the affidavit filed by
Yes.
respondent number 3, my lord.
Now, why is the petitioner number 2 before this court?
My lord, why? Because, my lord,
You have surrendered your license.
my lord, that is surrender with a condition, because
How can there be a condition in a surrender of a license?
this is not spontaneous.
Huh?
Lordship, kindly see page 35. Page
My
30.
question is, how can you surrender with a condition? Is it
That, my
possible?
lord, once the area officer called him in his office and asked him to surrender, because he said that, my lord, the petitioner is not eligible to continue as a PDS license holder due to his election as a Gau Panchayat member. That they had, my lord, admitted in their affidavit, my lord. So under the Panchayat Act, my lord, I have gone through, there is no such provision, my lord. With the bona fide
But
impression,
surrendered it.
my lord, with the bona fide impression that, my lord, they will allot it.
So now you want to change the situation
No, my lord.
after having surrendered. So let's see your surrender.
Surrender is, my lord, is not in my possession, my lord. They have taken some signature in blank paper that I have said in my affidavit also. Affidavit in reply. Lordship, kindly see page 35, my lord. Lordship, kindly see page 35. Affidavit in opposition filed by respondent number 3.
35.
Page 35.
Para?
Paragraph 6, man. That with regard to the statement made in paragraph 5 of the writ petition, the answering respondent beg to state that the petitioner number 2 so and so kept the district commissioner Barpeta as well as the Barpeta district panchayat election authorities in dark, violating the standing provision of section 11E of the Assam Panchayat 1994 as amended without submitting resignation or revocation of his fair price shop dealing license number so and so, thus misrepresenting and misguiding the government authorities. District Commissioner Barpeta, he has submitted his nomination on so and so 15/4/2025 as a candidate of the election to the GP ward member so and so. Accordingly, on being elected as GP ward member on 12/5/2025 and also taking oath as a
Mr. Council. As per section 111(1), holding a fair price shop is not an office of profit.
no 101, that is why, my lord,
What does he say?
I am reading out, my lord.
111(1).
Yes, my lord. E. Hold any service of profit under government or any educational institution recognized and receive grant from the government or holds remunerated office under the Jilla Parishad, Anchalik Panchayat and Gaon Panchayat, or holds any contract under the office of the aforesaid bodies or under the government. So here is a case, he is the PDS license holder. He only gets, my lord, the benefit after, my lord, supplying the product to the, my lord, public, and this is not a government job. So under,
Do you have a constitution with you? A constitution, copy of the constitution?
right now, I don't have.
The 243O article?
Yes, that is perhaps.
Fourth line, it will be covered loss. Then fourth line of subsection E loss will cover.
243O.
243O.
You are looking in the Panchayat Act, 243O.
Yeah, that is also there perhaps somewhere, 243. No, this is an amendment, constitutional amendment, my lord. It was perhaps brought in the.
Prepare properly.
Yes.
Okay.
Yes.
No stay.
No stay, my lord.
This matter, taking into account the Mr. J.M.H. Chaudhary, the legal counsel appearing on behalf of the petitioner, submits that he would further look into the provisions of the Constitution as to whether there is a bar in holding a license, a PDS license. No, as to whether holding a PDS license would come within the ambit of an office of profit in the Constitution. 243 E to sub. OP, no, tar agote aibo, OPJI. 43. This matter, when do you want it?
Any date, my lord, subject to your lordship convenience.
No urgency?
No, ma'am.
Okay. This matter on 23rd of September 2026.
Obliged.
32 lawsuit today I appear on behalf of
The
Mr.
caveat stands,
Mr.
Nature.
Gupta lawsuit. He is out of station, otherwise from, yes.
What is this matter?
Standard matter, my lord. The process was cancelled. I am the L1 bidder. They have cancelled it on the ground that the rate
That
quoted is 47% below the.
So this is the latest minister's resolution lawsuit. I don't make kindly go to it. Paragraph 4 lawsuit. Serial number 4 lawsuit. Sorry. আজি মই এনেই আহিবলৈ লৈছো, গোটা নাই।
Oh.
You want another one copy? Sir, desanction কৰিছে। Desanction কৰিছে, paragraph 4 to sub.
What does he say?
Lawsuit, it's desanction the whole project lawsuit, package 1 and package 3 lawsuit.
Here we are concerned with.
Package 3 lawsuit, package 1 and package 3 both are. So ground is that lawsuit, the combined they have to, is further been approved that the entire so and so corridor lawsuit, including the route from the junction so and so to so and so lawsuit, may be taken up subsequently as a single proposal lawsuit. Last 4 lines, my lord.
So now there is no question of issuance of a fresh tender without the sanction.
Lordship. Now it's a complete, it will be taken as a lawsuit, single proposal, and it will be done later on lawsuit.
You finally disrespect by way of an affidavit.
Lawsuit will do lawsuit.
Huh?
We'll do lawsuit.
Mr. K. Gogoi, the learned CGC submits that on 16/3/2026, the chief engineer PWD Manipur have been duly informed by the MOT that the package number 1 and package number 3 of the Songsak Nopal section of NH 102A have been deemed sanctioned. Section or it is sanctioned, huh? And therefore, which is one of the reasons for cancellation of the entire tender process. He further submitted that the question of issuance of a fresh tender at present does not arise till there is a sanction from the MOT.
Not lordship, it will be it will be also single proposal lordship. Now it will be come under single proposal.
MOT, there has to be a sanction. No?
Lordship.
The said it is the opinion of the court that this instruction, that this communication be brought on record by filing an affidavit. Mr. K. Gogoi, the learned CGC submits that the said affidavit will be 2 weeks.
Lordship, 10 days.
Really, we can
10
finish
days.
it off.
Within 10 days.
Nothing remains then.
Lordship.
Earlier they issued a fresh tender, my lord, and let your lordship state.
Everything.
Within 2 weeks. List this matter again on 14th of August 2026.
My lordship, please. I want to withdraw the case, my lord. I may be allowed to withdraw.
Mr. Upadhyay, learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. So and so appears for so and so. So taking into account the above, the instant writ petition therefore stands closed on withdrawal.
3, 4, 5.
I therefore say so and so, so and so. Put your names in golden letters, huh? What is this?
May it please your lordship. Lordship, I am aggrieved here by issuance of notices for demarcation, lordship.
What?
Yes, lordship. Lordship,
Who
kindly.
are you?
I am the possessor of the land, your lordship, the riot, lordship.
Oh.
Lordship, the fact of the case is that, lordship, the defendant number 4, being plaintiff, filed a title suit before the civil court, and the learned civil court had partly decreed the suit by declaring the possession in my favor and the khatian to be legal, lordship. And lordship, and in that plot of land, lordship, kindly peruse page number 157, lordship, of my writ petition. They have filed an application, lordship. 157, lordship.
What has happened here?
With due respect, I beg to state that I, Ruben Ramesh Chaudhuri, am the legal heir of so and so, who is recorded patadar of 9 bigha, 4.7 lasa, covered by so and so. The aforesaid plot of land has been possessing by unknown persons. Lordship, after the suit has been partly decreed, we have filed a RFA before this honorable court. And they have also filed an RFA before this honorable court. So both are being now before this honorable court and not decided, lordship. And during the pendency of this proceeding, they have filed this application to demarcate with possession of the aforesaid land in favor of respondent number 4, lordship. How can possession to be granted by way of demarcation, lordship? How can the circle officer exercise the power to hand over possession, lordship?
Respondent number 4.
Preparing for respondent number 4.
Okay, no problem. We close this petition with a direction that they can carry out the demarcation, but the possession of none of the parties shall be disturbed.
Because we are in the possession, lordship.
No, no. So
As in-
the possession of no party
Yes, lordship.
shall be disturbed because there is already a declaration.
Yes, lordship.
By the learned trial court.
Learned trial court, lordship.
So that declaration, as per the declaration, the possession will remain.
Yes, lordship.
Okay.
Lordship.
But they can carry out the demarcation. The demarcation is only to show the land, but not to disturb the possession of any of the parties.
Yes, Lordship. Yes, Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr.
2 and 3.
H. Sharma appears on behalf, additional senior government appears on behalf of the respondent number 2 and 3. Ms. Peach Borwa appears on behalf of the respondent number 4. The present petition has been filed by the petitioner being aggrieved by the issuance of notice dated 3/12/2025 in boundary case number 49/2025, whereby, isn't it?
Yes, Lordship.
Whereby
Lordship, three notices, Lordship. Notice
same
dated
issue, Lord.
on the same issue, Lordship.
Huh?
Three notices.
Where?
15/9/20.
Where are the three notices?
Page number 146 is the first notice.
Page
number 152 is the second notice.
These are different boundary cases.
No, same boundary case. We have filed objections also, but
Okay.
repeatedly
In
notices.
respect to the, is agreed by the various notices issued from time to time. And the last of which is the notice dated 3/12/2025 in connection with boundary case number 49/2025. The learned counsel appearing on behalf of the petitioner categorically submits that a dispute as regards the title and possession over the land in question, which is the subject matter of boundary dispute number 49/2025, was earlier pending before the before the civil courts in title suit number 95/2007. The said suit being title suit number 95/2007, which was filed by the predecessor in interest of the respondent number 4 against the petitioners, was disposed of by a judgment and decree dated 11th of December 2024, 2014,
14.
wherein it was held that the predecessor in interest of the plaintiff, respondent number 4, was entitled to the declaration of their rights, title and interest over the suit land, that is the Schedule B land. However, there was no consequential directions to disturb the possession of the petitioners. It has been further submitted that being aggrieved by the judgment and decree dated so and so, passed in title suit number 95/2007, appeal has been filed before this court by both the petitioners as well as the petitioner as well as the respondent number 4. The petitioner's appeal has been registered as
RFA 55 of 2015.
RFA 65/2015.
15. 55, huh?
55. Whereas the appeal filed by the respondent number 4 have been registered and numbered as RFA 51/2016. Is there any injunction?
No,
Stay?
Lordship. No, Lordship.
Nothing.
No.
No. The learned counsel appearing on behalf of the petitioner therefore submitted that when the suit is presently, when the dispute pertaining to right title interest as well as possession is presently pending before this court in the two first appeals, comma, the very continuation of the boundary dispute pending disposal of the boundary dispute in terms with the boundary the very continuation of the boundary case number 49 oblique 2025 is an abuse of the process of the court. Madam, I think he's right. I think we should stop it.
Lordship, actually, there is
No,
no
nothing
boundary
doing.
dispute as such.
How, no, isn't this the this particular plot of land?
Yes, your lordship.
He is in possession.
Yes, your lordship, he is in possession as an occupancy tenant. This is his submission, your lordship. Even the first line of the writ petition itself.
The matter is pending before the session. So what is required? If you want to do it, you file an application before the court.
Lordship, actually, lordship, if
Is
I may,
it the same subject matter?
subject matter is same, the land, but your lordship, we have asked for 9 week, the demarcation, because that is the dispute here that we are talking about. It is a the land is about 9 because which the application, which is an annexure, the application clearly mentioned is 9 because.
And
Lordship, the notice, if the lordship has annexure 3, the notice would clearly say that it is 9 because 4 letters. Annexure 3 at page 146, your lordship, the notice that was issued by the revenue department.
Yes.
Lordship has it. So lordship, in the paragraph, lordship would see it is plot of land measuring 9 because 4 letters. Thereafter, they are saying that they are in occupation. When they file the objection, they are saying they are in occupation about 10 because, your lordship. So if lordship, if the thing is that it is a fact that I am the landowner, Jamamandi records my name, my predecessor's name, and it is a fact that he himself has admitted that he is an occupancy tenant, your lordship. So in that case, all we are asking, just we will let the demarcation carry on. We are not disturbing the possession. For that, we have already initiated a
File
civil
an
suit.
application. File an application in the RFA.
We have, lordship, we have already
Take the
filed.
leave from that. I'll give you the leave. No, absolutely no. When the matter is pending, because Schedule B is that land.
Yes, your lordship.
Page 110, this is the land. That is why they are saying 10 bighas.
Yes, lordship. Page 43 also in your
Lordship,
claim, lordship.
Jamabundi says 9 bighas, and lordship,
Maybe, but Schedule B has been declared in your favor, which is 10 bighas. Page
yes,
110.
yes, your lordship. And lordship, there is also a civil suit pending where, because the order dated, there was also another decision passed by the civil judge, your lordship, which is dated in 2004. Which, if I can get lordship, actually we have not filed our affidavit in opposition. If we get some time.
I grant you the leave.
Yes, your
The
lordship.
boundary case shall be kept in abeyance till you get a permission from the in RFA.
In the RFA.
Yes.
You
take the permission from there and then proceed.
But your lordship,
You
lordship.
cannot, no. When the matter is disputed out there, you cannot. Sorry.
Lordship, there is a judgment by the Assam Board of Revenue, which on the basis of which we have already moved the civil court, which is pending. Lordship, there is a stay because.
I'm not on that. My
Yes, your
question is, if the dispute is pending before this court in RFA, you want to take the leave for proceeding with the boundary dispute? I give you that handle.
Yes, your
file
lordship.
an application, get an order.
In the RFA.
Once
All
you
right.
get an order, it will be proceeded.
All right, your lordship. Yes. Yeah.
This court also duly takes note of the submission of Ms. P. Borua, who appears on behalf of the respondent number 4, who categorically submits that the boundary case number 49/2025 pertains to a plot of land at measuring 9 bighas 4 lechas, bearing Dag number 5211 of EB Patta number 959 of village Kotasil under Moza Beltola. The council submits what is being sought in the boundary case number 49/2025 is only limited to demarcating the boundaries and not to interfere with the possession of either of the parties.
Yes,
This court have given an anxious consideration to the respective submissions, and it is the opinion of this court that when the dispute pertaining to a civil dispute pertaining when there is a civil dispute which is pending before this court in RFA numbers 51 oblique 2055.
55 of 2015 and 51 of
So
2016.
and so pending, comma, without taking the leave of this court in those proceedings, in either of this proceeding, to proceed with a boundary case number 49 oblique 2025 would have consequences in the adjudication of the RFA number so and so and so and so. Under such circumstances, it is therefore the opinion of this court that the proceedings of boundary case number 49 oblique 2025 cannot be proceeded with by the circle officer dispute revenue circle unless permitted by this court in RFA number. Your RFA is?
RFA is 51 of 2016.
In RFA 51 oblique 2016. Ms. So and so appearing on behalf of the respondent number 4 shall submits that appropriate application would be filed in the said proceedings. It is observed that the observations so made in the instant application, instant order, shall not impact the adjudication of such application if so filed in RFA number so and so by the respondent number 4. With above, the instant proceeding stands disposed of, thereby directing the respondent number 4. Respondent number? Respondent, circle officer. The respondent number 3. Not to proceed with so and so unless and until appropriate orders are passed in RFA number so and so 51. Huh?
Much obliged, Lordship.
May it please the lordship. My lord, the matter, my lord, relates to the construction of the foot overbridge.
Oh, that one.
My
What's
lord,
happened?
my lord, in terms of your
You're
lordship.
still fighting.
My lord, it's not. My lord, we have. My lord,
they categorically say it
yes,
will not fall in their land.
Lordship. My lord, in pursuant to my lord, the instructions which my learned friend has submitted on last occasion, your lordship had directed me to obtain instructions from my client, my lord. And my lord, we have had discussions, my lord, and certain things have emerged from their instructions, more particularly from the drawing that they have submitted with the instructions, my lord. My client had basically discussed this matter with her architect also, because this land has been given for development, which we have stated in our writ petition, my lord, that this same plot of land was given prior to acquisition, was given to development to a builder, my lord. So, my lord, now the point that they are raising, that this footbridge would not fall on the entrance of the petitioner's plot of land that is 10 feet wide road, and it will be adjacent to it, my lord. So, my lord, we have, the architect has provided a—
Mr. Counsel.
My lord,
no, first,
drawing, my lord.
no,
Kindly, my lord.
no, wait.
My lord.
My question is first.
My lord.
If they initiate such process,
My lord.
you can very well take those objections there. Why should this court look into this?
No, my lord. We are here because, my lord,
you approach at a time when you say that it is directly falling out there. Now, these are questions which the authorities can very well look into it.
Of course.
Why should this? When they tomorrow want to take over the land or anything which is happened, you will have an objection, or you to file an objection, you file it.
Yes, ma'am.
Have they initiated the process under Section 3?
That can be done, my lord.
So why this court should entertain this type of
Section 3, they have—
You want the foregone conclusion from this court, and then you cannot raise those disputes, and that too before this court.
Only because, my lord, my learned friend on the last occasion has said that it will not fall on the entrance gate.
So you stick there.
Yes, of course, my lord. But the project that we have, my lord, we have relating to development of land, the entrance needs to be—
Mr. Buragoya, you should therefore submit,
my lord,
that in view of their stand which is being taken here,
yes, my lord,
petitioner would not like to pursue the present proceeding. However, if proceedings for requisition or acquisition is taken, thereby affecting the petitioner would be granted the liberty to approach the authority, whoever it is,
First the land revenue authorities and then the
whoever, not the revenue, the DC,
DC, my lord.
will be the DC.
Yes, my lord.
The DC will be DC or the circle officer.
Circle officer.
Circle officer. In that, this notice has to be issued by DC.
For land acquisition, my lord. For under the 1964 Act, my lord.
Under the
DC
64 Act, they have issued it.
my lord, according to them, they have issued
In
it, my lord.
respect of so and so, it is to inform you that the land measuring 4 lesses covered by so and so Prohibition measure has been requisitioned under so and so. The acquisition process have been put on hold on account of filing of so and so. Okay, so therefore they have gone for requisitioning.
They have gone for
Okay.
acquisition, correct.
So now you requisitioning is only they do, although they only requisition only for the limited purpose to ascertain the feasibility.
Feasibility.
Isn't it?
Not so.
Then they go for section 6. So you approach and show it that what is the problem, and they have given some undertaking before this court.
Yes, my lord. 27 to order, it has been recorded.
Only for a while, for a moment, my lord may kindly have difficult presented a drawing, my lord. Kindly lordship may appreciate, my lord. This
From a perusal of the instruction, and more particularly to so and so, it is categorically mentioned that the plan of the food bridge is designed in such a manner that the minimum land is required and less utilities shifting for general public. It is also mentioned that the ingress and egress of the already existing main gate of the EI at the entrance facing the main road is not hampered by the proposed plan and remains unhindered, which allows the petitioner free access for entry and exit to the petitioner's plot of land as usual.
for just
This
one
is
moment.
the
Yes, my lord.
undertaking.
My lord, I admit that for just one moment, if your lordship may kindly see the drawing we have made, my just I'm sorry to trouble your lordship, my lord. Because this drawing, because even I was also under the impression that it will not hamper them. But after the architect has given the drawing by superimposing their drawing on our plot of land, this drawing has come out, my lord. The first drawing is the scenario wherein, my lord, my project, my land, your lordship will see, has been shown, my lord. That is the project which I undertake. And on at the beginning of this drawing, my lord, there is the entrance gate, which is 10 feet. Your lordship will see.
Where?
There's a 5-meter entry gate number 1. There is one, if your lordship sees, by red ink, my lord. Entry gate number 1 and entry gate number 2. In between is the current, my lord, the entrance gate of the petitioner. So, my lord, this is the current status. Now, if tomorrow the 4 acres of land are acquired, lordship may kindly turn to the next page. This is the superimposed drawing done by the architect, wherein the portion, if they take and establish and construct this particular footbridge, the width of the road, my lord, which is as per fire norms, is required to be, my lord, widened from 10 feet to, my lord, 5 meters minimum. So, a minute. So the current width is only 3 meters, my lord. Now, the moment they build this construction on my land, taking 4 acres, the entry and exit of my current road will further shrink, and I'll be not in a position to widen the road, my lord. That is a difficulty. So I'm not saying that your lordship should decide on these points, my lord, but they should also look into these my lord, aspects that we are raising, my lord. Because these are very fundamental.
Therefore, you,
Yes, my
as it is now,
Yes,
so
my lord.
therefore you approach them
Yes, my lord.
and place it all these things along
Yes, my
with the order of 27-2.
Yes, my lord. Yeah. This can be done, my
Don't you think so? That is a better option.
lord. Better option. This affidavit had been filed by us, my lord. Today we have filed, bring on record this documents, my lord.
What is this?
This is the fire norms I am given, my lord.
No, not this. See this particular thing, but they have given it to me. Hey, you have an extra copy? My goodness. What has happened? The government is not providing equal the government advocates. See this photograph?
Yes, sir.
The aerial view of the site they have taken one is difficult to
They are thinking of doing it here.
This is a new proposal they are giving, my lord. Is it a new proposal? Is it a new proposal they are submitting, but not on my land?
I don't know. That is what
even I'm not able to make out.
do one thing. A copy of the instruction, give it to him. take it up on some other day.
Yes, my lord.
Because we are also concerned of the fact that there is a delay and having not a overbridge or the footbridge
Lordship.
is acting a lot of difficulty for the people because after the flyover
There's
you
no
have
footbridge,
this
my lord,
and
correct.
then there,
Correct.
I think this will be nearby the downtown.
Downtown, correct.
Yes, my lord. In
So
front of
therefore,
the-
there needs to be something has to be worked out
Correct, ma'am.
somewhere, this
Correct,
way
ma'am.
or that way.
Correct.
And I also find that if you are going to do it, you may have to acquire more land, acquire it, but don't make the road squeezed out in that area. This is the biggest problem which we are facing out there in VS Road, as well as also while going towards that particular this what you call after the Pandu flyover.
Yes.
If you go beyond
I
that,
understand.
the Adabari area, this is a big. There's a this area is squeezed out, and thereby a 3 lane becomes 2 lane.
My lord, correct, ma'am.
I think here also, if you are because you have constructed these good flyovers out there, but these flyovers would be restricted because of this.
Correct, ma'am.
Which is we are finding it just near that particular what do you call the city center.
Yes, my lord.
There's always a traffic
Always a
jam
jam, my
because
lord.
of that
Correct, my
flyover,
lord, correct, my lord.
the footbridge.
Correct, my lord.
And you don't see any persons moving around there.
In the evening hours, my lord, there are people, my lord.
To see the lights, I suppose, the car lights. Otherwise, there cannot be any other. Anyway, Miss M. Bormon, the learned government advocate, has placed before this court a set of instructions which is kept on record and marked with the letter Y. The instruction is also provided to
My lord, it's not yet.
Mr. H. Buragoai
My lord.
so that he can also obtain necessary instructions. Must have list this matter again on when urgent, no urgent.
There's no urgency now, my lord. I mean, perhaps now, my lord.
No, we have an urgency because the acquisition proceedings have been put on hold because of this.
Next Friday, in that case, my lord. Coming Friday.
Friday will do, my lord.
On 8th of August 2026.
My affidavit is on record, I'll bring it on record, my lord. I'm obliged, my lord.
Obliged.
7.
Obliged, my lord.
Yes, what is this?
Please, Lordship. Lordship, this is the case, Lordship, for non-payment of ex gratia. Lordship, amount of rupees 50 lakhs to the petitioner, Lordship.
Affidavit, no affidavit.
The process. Lordship, I will see the instruction. It's under process, madam.
Under process.
Yes, madam. Forward to the finance department for concurrence, madam.
Where is the instruction? Ms. P. M. Monto, the Learning Council, appearing on behalf of the Revenue and Disaster Management Department, submits that the proposal for grant of the ex gratia to the petitioner is under process. And in that regard have placed an instruction dated 31/7/2026 issued by the Undersecretary to the Government of Assam, Revenue and Disaster Management Department. The said instruction is kept on record and marked with the letter X. Taking into account the above, list this matter on 9th of September 2026 for an update.
My lord.
Copy of the instruction may be served.
What?
Copy.
Not necessary. Here, copy is not necessary. It is under process.
Bless.
Whenever it is necessary, I'll give you.
37, my lords. 37.
What is this?
It's a matter of retendering or retendering process for 11.
Without any intimation to any of the parties, the respondent has put all the 11 numbers of contract works on retender. The last date for bid submission in the NIT dated so-and-so is there. So-and-so has contained that there is a violation and in for cancellation the reasons are to be recorded. Mr. Gogoi, list number matter on so-and-so. Having regard to the year, it is provided that for cancellation of the tender, reasons are to be recorded in writing in the decision to cancel the year for reasons and be immediately gone elsewhere. Ordered in the intent, the respondent may proceed with the tender, but process shall not without. Yes, you have a stay.
Yes, my lords.
There is no urgency.
No, there is some urgency, but my lord, unfortunately, my lord, we lost the brief. That file.
Brief?
That file, my lords. That file. My lord, we had reconstructed and send it again, my lords, for that affidavit.
No. So it doesn't seem to be you have no urgency.
No, we have urgency.
Then
work is on hold.
why 22-5, 22-4, 23-3?
Instruction have been received, affidavit was sent for vetting, my lords.
When
They
did
don't-
you lose?
My lord, we lost it around 15 days, 13 days dead back, my lords. We are reconstructing our chamber. Mr. Goswami's chamber was reconstructed. At that point of time, my lord, we lost it.
You want the copy?
My lords?
You want a copy of the petition?
No, we can reconstruct. We had reconstructed, my lord. We applied for a certified copy now.
When do we expect the reply?
My lord, 2 weeks.
Have you provided the petitioner the reasons?
My lord, that has come with instructions that we have
There
inserted
was
that in the.
specific direction passed by the learned coordinate bench to provide the reasons to all the bidders?
That will be
Are
taken
you
care of.
aware of the order of
My lords, no,
23,
that will be taken care of by the affidavit, my lord, which will be filing, my lords.
No, there was a specific, it provided that for cancellation of so and so and the reasons for the decision shall immediately be communicated to all bidders that participated in the tender process.
That
There's
was,
a direction.
the commandant was communicated, my lord. I have to take instruction whether he has communicated or not, my lords.
Shall. The respondent in the forest department have not filed the affidavit in opposition. In spite of there being a stay order passed on 23/3/2026. It has been informed that the respondents in the forest department have not been able to trace out the file. Considering the above, list this matter on 11th of September 2026. In the meantime, the intent taking into account that the respondents have not filed their affidavit in opposition, the interim order which was passed on 23/3/2026 stands extended until further orders.
Deeply obliged.
What is this?
Lordship, as per the last order, we have filed a rejoinder. It's a matter pertaining to withholdment of performance bank guarantee, Your Lordship.
We have filed our
Why haven't you returned it?
because it has been set off against LD claims, Lordship. If a Lordship will come to, the affidavit pays 415
Okay, so this is against the LD claims.
LD claim, and that has been
And they
already
filed a
accepted,
reply.
Lordship.
We have filed a rejoinder.
Yes. And in
the-
fact, they had at one point of time already accepted to the same. They were terminated at one point of time. There was an MOU. They were reinstated. And at that point of time, there was an understanding that the LD will be deducted in for so far as mobilization delay was concerned. So this money that they are claiming is a part of that liquidated damage that has been deducted. And there's already,
How much is the liquidity damage?
in fact, it is more. Now we have filed the counter claim. There's in fact an arbitration going on.
Your Lordship,
Wherein they
there's
have
a
not
little
raised this
urgency
claim.
in the matter. I would wait for my senior counsel to complete, then I'll apprise Your Lordship.
In fact, there's an arbitration
The
going on where they have
arbitration-
raised certain claims, barring this claim, for which they have come on a writ petition. But now we have filed a counterclaim there because of the additional amount that we need to deduct insofar as the LD is concerned.
Your Lordship, there is a statement of defense. There is no counterclaim with regards to the damages pertaining to the performance security as far as what I am aware of. They have not
Okay,
filed a
you find
counterclaim.
out. You have filed, have they mentioned all these things in their affidavit?
I don't think so, Your Lordship, because statement of defense before the arbitral proceedings have nothing with regards to this. In fact, this particular communication that they're referring to is also much subsequent to the writ proceedings that had initiated.
We then do one thing, you have filed your reply. We have it on 10th of September for final discussion. Taking into account that no further pleadings will be filed and an urgency has been expressed by the learning counsel for the petitioner. Matter stands adjourned to be listed on 10th of September 2026, on which date an attempt shall be made to dispose of the petition.
Thank you, Lordship.
Yes.
My lord, first of all, I beg apology, my lord. I ought to have filed my rejoinder affidavit, but some document will lack. But today morning we have received those documents, my lord.
You are filing your rejoinder affidavit.
Only 10 days time maybe, today morning. we-
Counsel appearing on behalf of the petitioner submits that 10 days time may be granted for filing the affidavit in reply. List this matter again on 7th of September 2026. In the meantime, the affidavit in reply be filed. Interim order passed earlier shall continue till the next.
Hello,
day. Okay. Yes.
May it please your lordship. My lord, I have challenged here an order passed by the Board of Revenue, my lord. In this regard, my lord, today fixed for affidavit filed by the private respondent and respondent number 4. Respondent number 4 has filed an affidavit, my lord.
4 has filed.
Yes, lordship.
You are for?
I'm for 5 to 8, lordship.
What is the matter about?
My lord, matter regarding that.
Before the circle, it's a Board of Revenue order.
Yes, your lordship.
Hello. This is all our service affected.
Yes, sir.
Yes, my lord.
Okay, the service being affected, the a final opportunity is granted to the respondents to bring on record their stance. The respondents who have not filed their affidavits to bring on record their stand. List this matter on 23rd of September 2026.
Oblige, your lordship.
Yes, what case you have? No case.
May please, Your Lordship. Your Lordship had put a query along with the judgment. I have gone through that. But before that, I would like to apprise this Honorable Court about the prayer that we had made about the non-registration of 2 FIRs. If Your Lordship may kindly come to page number 5, para number 9. The first FIR was lodged on 10/11/2025. The petitioner was subjected to series of outrageous, degrading, and criminal acts at the hands of the accused. On 4/11/2025, the accused committed an extremely reprehensible and shocking act by deliberately defecating within the premises of the petitioner's residence. The said act was not accidental but was calculated, intentional, and executed with a
Who is
small.
the accused?
Accused is Kushal Kalita.
Yes. Now, heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. Endas appears on behalf of the government of a learned government advocate. The present petition has been filed by the petitioner, being aggrieved by the non-registration of the FIR filed by the petitioner against the accused persons, and also to take immediate action against the accused persons as per law. It is the opinion of this court that if the petitioner is aggrieved by the non-registration of the FIR or non-registration of the FIR, the remedy of the petitioner lies under section 175 bracket 3 of the B Bharatiya Nagarik Suraksha Sanhita 2023. And taking into account the judgment of the Supreme Court in the case of Sakira versus State of UP and others reported in so-and-so 2008 to SCC 409. This court is not inclined to entertain the instant petition. Accordingly, the petition stands dismissed on being not entertained without prejudice. Rights of the petitioner to approach the concerned jurisdiction and magistrate if so advised.
Little concession, man. Your lordship has passed. Nothing to say, man. Sakri Bushu, my lord, the judgment that your lordship has offered, referred the other day, my lord, there is not even a jurisdictional restrictions, or it's not there is any absolute bar to that extent. I'm not on that, man. The prayer for which the writ petition was filed, done, my lord. It is resolved. But the only thing is that, my lord, I think I need to apprise your lordship what happens actually. I am a practicing lawyer. I'm a lady lawyer. My husband was also a lawyer, my lord. He died. Now, in one day, when I was returning from the court, this accused particular fellow, my lord, he has a shop near my residence, covering certain part of my entrance. Now, in one day when I was returning to my home with my little kid, my lord, a garbage bag was thrown into my car. To that extent, I just objected what happened. And to that extent, my lord, the accused and his wife pulled me in my advocates attire, and I was at that particular point of time, into their shop. I was brutally assaulted. My entire robe was torn apart. And with that state of, my lord, affairs, I went to the police station. I filed an FIR that was not registered. And thereafter, my lord, I waited about 30 days, my lord. Then after I filed a representation, my lord. Your lordship, I filed a representation to the commissioner of police with a video evidence. Nothing was done. And thereafter waited 36 days. Then I filed this writ petition, my lord.
Next.
Obliged to.
Mr. Counsel, I have adopted a same approach for each litigant.
My lord.
Same approach. I cannot give a special.
I'm not
treatment
seeking.
So therefore, what you say
My lord.
absolutely comes within the ambit of Sakila Vasu.
But that's all, your lordship.
For concerned person who is to swear the affidavit, my lord.
Yeah.
His mother expired. Ritual should be over by coming Sunday. He'll be joining office on Monday. By Tuesday, he'll be swearing the affidavit, my lord.
What is the matter about?
Co-district commissioner.
What has happened?
My lord, I have met party, my lord, co-district commissioner as a respondent.
Whereby
number
this
12.
court has directed to dispose of a representation on the basis of which statement of ward member. What is the matter about?
My lord, the matter, my lord,
Whereby representation of the petitioners against the election and selection of the areas as president and vice president of so and so pursuant to the order dated has been rejected. Then service on which state and the next this court shall consider as to whether the any is required to be passed. Now, affidavit
It will be taken on Wednesday, my lord. By Tuesday, the affidavit will be filed, my lord.
taking into account the reasons so assigned by Mr. M. Das, the learned junior government advocate, the matter stands adjourned to be listed on 14th of August 2026. In the meantime, the respondent, the co-district commissioner Dalgaon, shall file their affidavit on or before 12th of August 2026.
Mark to question.
Mr. Arshoma, what is your matter again?
My lord, we had filed this petition. We are a telegraph authority. We are filing this petition for obstruction of a right of way for transmission lines for constructing transmission lines. My lord, this is
constructing
obstructing our building of transmission lines, my lord, because we are a telegraph authority by virtue of the official gazette.
Who is obstructing?
But the landowners. So we had filed an application under 16(1) of the Indian Telegraph Act to the district magistrate so as to clear the right of way, my lord, but that has not been done for months. And a similar matter was also heard, my lord, but inadvertently, same matters arising out of two districts have come in two different courts today.
Oh, what happened?
There, my lord, what the respondents are saying, the BTC, it comes from BTC. The BTC is saying that due to the rainy season, we have not been able to do anything.
Huh?
Due to the rainy season, we have not been able to do anything. That's what the district magistrate says. Now, I don't know what my learned friend here has, what kind of instruction.
I'm appearing. What happened in that matter?
Fixed on 14th. It is fixed on 14th, my lord.
14th
of August.
List this matter on 14th of August along with
WPC 3236 of 2026. Obliged. Obliged.
I have received my instruction, madam. But to allow me 3 weeks time to file my affidavit, madam.
you're filing affidavit. Okay, the respondent GMC 6 for time for filing affidavit to stop, taking into account that no affidavit has been filed, though notice was issued on 24/6/2026. It is the opinion of this court that the interim order passed by this court on 24/6/2026 be extended until further orders. This court further grants the respondent GMC to bring on record its time to bring on record its stand by filing the affidavits by 9th of September 2026. List the matter on 16th of September 2026.
May it please your lordship.
Oh. Yes.
Lordship, I have judgment.
Okay, not today, huh? I don't have the time today.
Okay, lordship.
In fact, the matter, when was it fixed? Why is it fixed today? Okay.
Lordship,
The question which have been framed by this court on 13/7/2026 would require a further elaborate hearing, and on account of paucity of time, the matters therefore stands adjourned to be listed again on 8th of September 2026. Mala scheme. Yes, what has happened?
Well, I have gone through the records. But some processes they have undertaken, but not the entire. In respect of the petitioner, I have not seen the entire procedure they have followed. But in respect of some other persons, I have seen the settlement agreements where negotiation agreements were signed, and accordingly payments were also made out of this particular process.
Are you passing awards on the basis of that?
Award statement I have seen.
Are you passing awards?
As such, well, specific, I have not
There is a
seen.
difference between award statements and awards.
No, in this
award statement, if you see the Land Acquisition Act 1894, is an award statement is made under 19, but an award is made under 11.
True. True.
So are you making these awards?
No, in the records, I have already seen the award
Why
statement.
don't you give some training to your officers?
Lordship,
Because you see, it is high time, because you are taking over somebody's rights. And later on, we are more concerned about the interest accruement.
True, true.
It's a very difficult thing.
True.
Okay, we do one thing. You have filed your affidavit, you got your records?
Well, the records I have got. Affidavit was filed, but a lot of things are there, but those are not incorporated. Some additional affidavit.
You want to file an additional affidavit. How much time?
Lordship may give us 10 days time, or 2 weeks time I will give him.
Mr. Dina, the learned senior government advocate, submits that the affidavit which have been filed earlier do not appear to be adequate, taking into account that various aspects which have been mentioned in the records are not available. He therefore submits that an opportunity may be granted to file an additional affidavit. Full stop. Taking into account the above, list this matter again on 28/2026. Full stop. The additional affidavit be filed on or before 12th of August 2026. Liberty given to the petitioner to file reply to the additional affidavit as well as to the affidavit so filed by the petition respondents in the meantime. Full stop. The records of the acquisition as sought for by the order dated 27/7/2026 be placed before this court on the next date. Liberty given to the petitioner to mention the matter for upgrading.
Not much.
In this case,
Mediation
Yes,
done.
mediation was successful, your lordship. Lordship. may I
Also,
please-
that the parties have resolved the dispute, the AIA is agreed to pay the revised amount of AIA to the imam for the period from so and so. You will release the amount of AIA to be by adjusting the same, the amount of so and so the earlier. What is this?
The mediation was successful, your lordship.
Mediation successful.
Yes, because we have issued an order, a letter, lordship.
You are appearing for?
I am appearing for all the respondents, your lordship.
So you are going to make the payment?
No, lordship.
They will deduct from
I will
my-
deduct, lordship, the payment is with us.
Ah.
We have kept in hold. Lordship,
the amount, the penalty was 8 lakh something or amount. Now it has been reduced to 20,000 something. odd. Lordship, that's why after keeping 20,000, we release the amount, Lordship.
To the entitlement of the
Some
petitioner.
amount
is pending before. You have heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. DJ Das appears on behalf of the respondent numbers 1 to 9.
1 to 9, Lordship.
Pusto. This court duly takes note of that by an order dated 16/6/2026, the present proceedings was referred to a mediator for an amicable settlement by way of mediation. This court further takes note of that the mediator had submitted a memorandum of settlement dated 31/7/2026. The said memorandum of settlement is kept on record and marked with the letter X. So this court have duly heard the learned counsels appearing on behalf of the parties and have also perused the memorandum of settlement kept on record and marked with the letter X. It is the opinion of this court that the memorandum of settlement so arrived at is a fair resolution to the said dispute, and the same have been arrived at without any fraud, coercion, or fraud or coercion. Accordingly, the parties to the present proceedings shall be bound by the terms and conditions of the memorandum of settlement, which is kept on record and marked with the letter X. The above, the instant proceedings stands disposed.
Lovely.
Mr. Bora, where are you? Yes.
My affidavit, my lord.
Filed affidavit.
They have filed their affidavit and the stand taken by them is.
I'm not on that.
Yes, they have filed their affidavit, my lord, by fix. Next week, my lord. They are saying these are minimal spillovers.
What?
These are minimal, my lord, will kindly see this way. And they want my sale deed, though these lands were acquired through my predecessor in interest, it is an inherited property.
You file your reply.
But reply I'll file, my lord.
You don't want?
Yes, absolutely, I'll file my reply.
Then
with videographic
Mr.
proof,
M.
I'll file.
Biswas, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit in opposition filed by the respondent number 4. When?
My lord, I'll file any day next week, maybe by.
Accordingly, list this matter on 19th of August 2026. In the meantime, the affidavit in reply be filed.
Apologies, Lordship. Lordship, item number 50, Lordship. Actually, it was a special consideration.
Huh?
Lordship. And item number 50, the amicable settlement was a special consideration. It should not be treated as a precedent, Your Lordship. That observation may be given, Your Lordship. It should not be treated as a precedent, Lordship.
Is it mentioned in as per the terms and conditions?
But Lordship, it may, some floodgate may be open, Your Lordship. Everyone will come with that.
Anyways, okay, I'll put that, whatever, let me think about.
Lordship, much of
Put the right word. Yes, what is this? Mr. Jain,
Yes, my lord. Undisputed.
what are resource?
Undisputed, my lord. We are ready to, willing to pay. We are ready to pay.
What is that?
Yes.
What amount?
3,85,014 only, my lord. 10% of the amount, 10% remaining is outside.
2 months time may be given, Your Lordship, for the payment.
You are willing to pay?
Yes, but 2 months time may be given. We have to.
That I am
arrange-
going to, have you mentioned it in the affidavit?
Yes. Not
What
di-
have you stated in your affidavit?
Not directly.
Huh?
Not, we have not,
But why are you saying that you are willing to pay?
no, we will pay you.
What? Why you are saying that you are willing to pay? If you have not stated in your affidavit?
Amount has been,
You know the consequence, Mr. Counsel. What's your name?
K. Bhattacharya.
Then
Admitted amount, my lord,
where is your admission?
amount is admitted. That's
Where
what,
have you mentioned in your affidavit?
in the point 4, your lordship.
You have not mentioned out there. You said some payment are still
Yes,
pending.
some
You have
pay-
not stated what is the amount.
Is that the security deposit amount? Actually.
Here he is asking for you, I agree thereby so and so. After releasing 90% of the final bill amount, 10% has
Yeah.
not been released.
Yes,
Then
on
why you are saying that
6
security deposit amount?
10%.
Have you read the file or not?
Yes, your lordship.
Then,
That part only left.
first
for
of all,
final.
your affidavit does not say anything.
In
You are
sim-
saying all these things.
In similar case, my lord, the order passed by the honorable court. In the similar case, my lord, this order has been.
That's a different thing. But he is saying the what? We are going to pay within 2 months. First of all, today, if we say that, he doesn't have instructions to that.
No, I have the instruction.
Where is your written instructions? In your affidavit, you are not quantifying it.
Yes, your lordship.
Then
We have not directly mentioned. In the para, your lordship, may I read the para? No. However, some payments still pending to made to the
No.
petitioner, which shall be paid after finalizing the
No.
accounts.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent number
1 and 2.
1 and 2 submits that the respondents duly admits that an amount of rupees 3,85,014 is payable to the petitioner. Full stop. It is the opinion of this court that merely on the basis of a submission made by the counsel, that too when the affidavit filed by the respondent number 1 and 2 do not specifically mention, this court cannot accept the said statement. So accordingly, the respondent numbers 1 and 2 are directed to file an additional affidavit as to whether the respondents duly admit to the amount of rupees 3,85,014. Full stop. List this matter again on 21st of August 2026. In the meantime, the affidavit be filed on or before, additional affidavit be filed on or before by the respondent number 1 and 2.
Hello.
May I please? On the last occasion, my lord, respondent directed to furnish instruction, my lord, affidavit.
The land is, real estate of the highway, my lord. And on the day of my lord, land evaluation, my lord, he has indicated my whether it,
There is an order to file affidavit, my lord. Last order, lord.
Okay. Additional affidavit filed.
Yes, filed. That not on record, my lord.
And what is your stand? No,
on the
his
day of,
stand.
on the day of evaluation, land evaluation, my lord, he has not indicated, my lord, whether it comes under, my lord, the urban area or my lord, the real estate, my lord.
Now, that I understand.
Nor
I
he
have
filed
issued
any-
that notice in this case.
No,
Or this, I have heard it on that last occasion.
yes, lord. But so far, the representation is concerned, it is not on our record, my lord. He has not filed any representation before us, my lord, also, my lord.
Okay, we take it up on some other day.
Yes, my lord.
My lord, next week, if your lordship, my lord.
They have filed affidavit in opposition.
No, my lord.
No, my
Who
lord.
has filed the respond number 4 is who?
Is the
Deputy
state, my
Commissioner,
lord.
my lord.
Huh?
Deputy Commissioner.
But it is neither here, neither.
Hello. You are going to file your affidavit?
This is an instance, so it will suffice, my lord.
Okay, take. The respondent numbers 1, 2, and 3. Mr. S. Bottakar appearing on behalf of the respondent numbers 1, 2, and 3 submits that the said respondents would not like to file any affidavit. 1 and 2.
Yes, 1 and 2, my lord.
Full stop. It is also seen that respondent number 4 has filed an affidavit. Mr. Bottakar has placed before this court an instruction which is kept on record and marked with the letter X. A copy of the instruction be provided to the learned counsel appearing on behalf of the petitioner. List this matter on 17th of August 2026 at 2 p.m. for final disposal.
Obliged.
Hearing your lordship, I have earlier filed a representation on 25/7/25. Either to grant remission or to accept surrender of the fishery, your lordship. Subsequently, they have made a communication whereby they have said they are not able to find out the representation dated 25/7/25, your lordship. So I may be granted liberty to again submit that representation, your lordship.
No, even in his annexer lordship, page number 60, there is no scene of received copy or something.
There are many representations.
That
You have
so
not
far as
raised objection to
representation
that.
concerning
This
25/7/25.
matter again on 5th of August 2026 for further consideration.
I may furnish a copy of the earlier representation, your lordship. That liberty.
You have filed an IE?
No, no, earlier I have filed a representation for either to grant remission or to accept my surrender, your lordship. Subsequently, I have filed another representation. Now they have made a communication that they are not able to trace out that representation. So I may be granted liberty to again.
Let's have that and bring on record by filing an affidavit. Or do one thing, okay, well, let's have it on 5/8. On that day, we will pass on.